Hi, chat. Hello. How are you guys doing? Hope you guys are doing well. And tonight we're going to try something. I don't know how this argument actually goes because I didn't listen to it yet, but I do think it's interesting for a couple different reasons. Like one of the first big things is it's not Trump. It's not a Trump case. It's something outside of that. This goes to the Eighth Amendment, really, at this point, and it's about the idea that if you are mentally handicapped and you are, you're mentally retarded, um, can you be executed? And that's something that we've had to deal with now. It's been a thing that's, for the longest time. Could we execute somebody who's insane? Well, the Supreme Court said you can't do that. And this is an ongoing thing about here. How do we do this? And you're going to hear these. You're going to hear a couple different court cases go on here. But one of the big ones you're going to hear is Atkins v. Virginia. And that was one where it says you have to take like a holistic approach to determine whether or not somebody can be executed, whether it's righteous or not. And there's a lot to address. There's a lot to look into, and we have to make the proper decisions about it. And that is where we start today. At this point, you have Hamm versus Smith. And I call the sandwich jokes aside. Yes. Huckle, chuckle, 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 chuckle. About Hamm. I know that's what we're going to say here. It brings us to a very interesting situation, though, about what do we do here when somebody has a lot of the characteristics of somebody who's very low on the IQ charts, but they're not all the way there. And when this whole thing starts, this goes back to 1997. And that's where we begin our story. And in 1997, Joseph Clifton Smith was arrested, and he was charged with the murder of a man that he's allegedly beat to death. Joseph Smith is a guy who dropped out of the 7th grade. When he was arrested, he could, articulate and do things at a very low level. Like his math allegedly was like that of a kindergartner, his math skills, for example. They IQ tested him a couple different times, and his IQ test all came in between 72 to 78. And remember the cutoff, and this is something, Jordan Peterson's talked to us about, the IQ range for the military, 83 is the cutoff. If you're below an 83, they do not have jobs that they could teach you how to do things. It's actually problematic for them. So IQ chart, like the IQ is a serious thing. And when you look at an IQ here, 70 is considered low intelligence. Like you have a disability. And it's significant. A 70 IQ is, like we're at the bottom end of the bell curve, guys. And if you have never seen an IQ chart, here we go. And from here you can see there's, average is right here, and this is where like a lot of people are right here. Between 90 and 110. And 70 is all the way down here. And from 70, like dealing people with very low IQ, it's a very real thing. It's a very real thing to deal with. It's very developmentally problematic for them. They're very hard to function in society on top of other things. How many can even comment on the YouTube chat? Well, that's, yeah. Jane says you need about a 50 to ride a bike. And that's true. That's true. What's dark side Phil's IQ? I don't know. But remember, most people, roughly speaking, 70% of us, 70% of the population is between 85 and 120. So really, from about here to about right here is about 70% of the population in any time. And I'm probably about right there. A little bit smarter than the average bear. A little bit smarter than the average bear, if I had to guess. But Somali cast IRL, thank you, Killbilly. In all seriousness, though, it's really important. It's really important. What's the limit for the military? It's 83. 83 is the limit for IQ. I wonder how standard curved IQ really is. We have to function, and it's scientifically proven the bell curve and the standard distributions. It's correct. It's correct. It's like the meme shows. The caveman thing on the end, there's the Jedi thing on the other end, and then in the middle is the midwit losing his mind. But remember, at 72, you're kind of in Forrest Gump territory. So remember, guys, part of Forrest Gump's thing was he was stupid, but he didn't fall below a certain level. He was too smart to be considered dumb, but he is too dumb to be considered smart. So he was at 74 IQ, I think, even if you remember watching the movie. He's just outside of it. Now, 70 is kind of like a de facto, that's the de facto, the way courts had looked at it it's like 0.08. If you're at that level, there's a presumption you are developmentally disabled. In this case, he got a 72. Now, his attorneys have made arguments. Hey, wait. Technically, there's a margin of error. It's about 3 points. So one of these, he would have qualified. But remember, courts have said, no, you have to do a holistic approach here. Now, in Alabama, they went through everything, and they said, nope, he's not. He is okay to execute. He appealed all the way up to the 11th Circuit. The 11th Circuit said, we don't think he did it the right way. The state of Alabama immediately appealed to the Supreme Court. Supreme Court took it, and they immediately set it back down because they were confused about the way the 11th Circuit framed it about a year and a half ago. And they said, they said, why are you talking about IQ so much? And the 11th Circuit had to say, we're not saying IQ is the only determinative factor, but certainly if you're at 69, that says a lot. But even at 69, that's not a determinative factor alone, which is kind of like a wait. Like you're saying now that becomes a conflict issue between the circuits. It's like, how smart do you have to be executed? And that's where we're at now. That's where we're at. So we're going to take a look at this, and we're going to see what happens. We're going to see what happens here. And, yeah. They basically said, the 11th Circuit said Alabama never did the holistic approach. So we're going to go from here, and we're going to do this. You guys are trying to. 70 IQ, how many years ago? The IQ of today has moved up, making the 100 average of today like a 118 or more decades ago. Really? Blocks are saying, is 70 an excuse for not knowing the law? No, it's not. But at some point, the idea that you can execute like that person, if they really don't understand what the hell's going on, like, no, I think you have to jail them or warehouse them, fine. But yeah, if they can't really fathom what's going on, I don't know if you can execute that person. I don't know if that's fair. Maybe in the end, for some of those people, that might be the best thing for them. Kind of like in Mice and Men. What was it best for George to get shot? Probably. Was it probably right for Lenny to do him up? So let me see here. It's Minecrafting time. Kitchen Knife Rescue on a lighter note says MC Jarbo is back. Wow, interesting. Joseph Smith is a Mormon prophet. Yeah, well, there's more than one guy known as Joseph Smith. Okay, there's more than one guy. And all these, yes, there's a lot of there are all kinds of Somali comments here. This is just beautiful. This is beautiful. Love it 2 times says, I haven't seen you in forever. I don't know if you've been streaming or not showing up. Nope, been here hanging out. So good to see you. Good to see you. You're from Plain City. Well, there you go. Plain City's nice. It's not Somali dominated yet. So there you go. There you go. And then real quick, we got some comments here. EDW Raptor says for $6.70, 6-7. Thank you. Tilly, good to see you. Says Sean fell down fixing the fence. He got stuck. No, like we've had the wind still been whipping through. Like the fence would, if I fix it right now, it'd probably fall apart. Hopefully can get it done tomorrow when the wind quits blowing. Brad says the only way to make up for this is to show Louis. Well, Louis's gone. Louis went back to his owner. So can't help you there. Can't give you what I don't have. Also, that includes the actual quality entertainment as well. I can't give you what I don't have. EDW Raptor says Forrest Gump had a low IQ and his mother managed to get him into school with all the normal kids. Yep. Yep. Chugi Show says late in review bombing a Substack. Aranda wrote about him. Say la vie. Say la vie. Maelstrom says this is putting the square peg in the round hole territory. Well, from what I've heard, this is an interesting argument. So, like I said, we'll try it and we'll see what happens. BobTube says for $2, sorry, Dabbleverse, your service is not required. And Stephen Cooper says Forrest Gump was a new standards man. Yes. Yes, he was. So, let's see here. So I cannot be executed. Awesome. I get a freebie. Well, that's what I was going to say. This is very important, though, for you guys. Because you need to know, can you be executed or not? Especially being my chat, you need to know specifically, are you at risk? You might be, you might not be. Very important for you to know this. Kurt says, IQD's nuts. Oh, funny. Black Hawk Down, too tarded. Well, yes, that is a whole. I love all the memes coming out of Minneapolis, all the Black Hawk Down memes. There's this guy, Julio Rosas. He's a reporter, and he's been using Black Hawk Down memes for all the reporting. It's hilarious so far. So, Kurt, does this mean we're all safe from execution? It means I'm safe from execution. I don't know about you. You're smarter than I am, but yes, I'm probably safe. I'm probably safe. Did KBJ recuse herself? She's like, this could be me. Oh. Lenny had it coming. Oh, was it Lenny? I forget if it was Lenny or George, but yeah, Lenny had it coming. Yeah. So. All right, let's get started here. Let's get started. So we are going to try this. Let me see. Let me grab. Where's this? All right, we're going to try these from Ryan Mullally. He kind of gave us some. I think this will work. So this is, like I said, we're going to try this out. Let's see if this works. This is Ryan Mullally kind of tipped me off to this and was using it. This is a Supreme Court oral arguments transcripts. This might be a little bit. This is going to be more in time. The closed captioning is going to work. So that's why we're going to try this tonight and see how well this goes for us. We're going to do a little bit of faster playback speed, and we'll put this up here. So here we go, guys.
24-872, Hamm versus Smith. Mr. Overing?
Mr. Chief Justice, and may it please the court. Nothing in the Eighth Amendment bars the sentence Joseph Smith received for murdering Dirk Van Dam nearly 30 years ago. Atkins created an exception for offenders known to be intellectually disabled, but Smith is not. He didn't come close to proving an IQ of 70 or below with scores of 75, 74, 72, 78, and 74. But the lower courts changed the rules. First, misreading Hall, they took the lowest score to represent a possibility that Smith's IQ is 69. Then, to the extent they considered other scores.
Okay, real quick. Do these tests test for malingering? Yes. These IQ tests, all these things, they're very able to quickly tell when you're malingering and you're faking it. When it comes to the insanity tests, it's very difficult to fake those. You can't fake the funk. They are very good at sniffing that out. And a lot of that's because most people don't understand how crazy people act. So you have an idea of how a crazy person acts, but you really don't know because you're really not crazy. So it's very difficult to do. So don't panic that everybody's going to figure out how to do this. How this all plays out, you don't have to do that. So here we go. But it's a good question.
They took each only in isolation and moved the line to 75. These maneuvers expanded Atkins, and this court should reverse that expansion. First, because it was not authorized by the Eighth Amendment. Second, because it would eliminate state discretion. And third, because it ignores that the combined effect of multiple IQ scores reduces error and yields a more accurate estimate. The answer to whether courts may consider the cumulative effect of multiple IQ scores is yes. The answer to how they handle multiple scores is not found in the Eighth Amendment and thus left to state discretion. Still, this court can offer some meaningful ground rules for how to handle multiple scores. First, states are allowed to make the first prong turn on the very best evidence of intellectual functioning, IQ. Second, states are allowed to define the requisite intellectual functioning as an IQ of 70 or below. Third, states are allowed to require the claimant to prove his IQ by a preponderance of the evidence. The court can then supply a durable rule of decision by which a state can adopt a reasonably reliable method for handling multiple IQ scores that when it suggests the offender's IQ is greater than 70, his sentence does not violate Atkins. Here, every identified method of handling multiple IQ scores favors the conclusion that Smith is not intellectually disabled. I welcome the court's questions.
How would you specifically handle the multiple scores here?
In this case, the consistent evidence is that Smith's IQ is above 70, and we've offered 5 different ways to see that, but we think ultimately it's Smith's burden to come with a method that proves that his IQ is likely below 70.
So what did is the test whether or not it is likely or is?
Likely below 70 is our understanding of the preponderance burden in Alabama. Other states are free to adopt other burdens of proof.
And what was the finding of the Court of Appeals and the District Court?
The sentence, Smith's IQ is below 70, doesn't appear in the District Court's opinion nor in the Court of Appeals' opinion. They found the first prong satisfied by a preponderance of evidence, but only after they changed the standard to be not just intellectual functioning, but not just IQ, but a broader conception of intellectual functioning.
What if the scores were 69, 68, 69, 69, 75? I mean, would you concede in that case that it was the actual IQ is below 70, or would you still argue, well, 75 is above, so we're going to look at all sorts of other things?
Well, the burden would still be on the offender to prove a likelihood that his IQ is 70 or below, and so he'd have to come with a method. Here, Smith did.
He'd have to come with a what?
With a method for assessing those scores. Here, Smith didn't, so his claim fails. We have an argument that the highest score should be given more probative weight because there are many ways that an IQ test can underestimate IQ if the offender is distracted, fatigued, ill, or because of the incentive to avoid the death penalty.
Well, it does see, you can see why that might be regarded as a little results-oriented. When you have scores above 70, you want to average them and discount the one below. But when they're all below, you don't do that. You instead say you got to look at all these other factors.
It's not results-oriented, Your Honor, because there is a scientific warrant behind it. And we have to think about what IQ tests are doing. They're trying to measure the...
It's a very good point. It's a very good point here. I think at some point, like, how do you handle this? How do you do it? The guy's like, well, and the judge's like, well, how the fuck are you supposed to prove that? And I think that's a very problematic statement here. For the, and remember when they say on the defendant, they don't mean him specifically because obviously he's mentally handicapped, but it would be his attorneys and stuff, guys.
capacity for intellectual performance. And so someone's best score is the best representation.
But Mr. Overing, it seems to me that you are actually changing the standard. You've accused the district court and the Court of Appeals of doing so, but in our case law, consistently, we've said that the first prong relates to a showing of significant sub-average general intellectual functioning. The words IQ score under 70 does not appear. That's not the standard. I appreciate that that's one of the ways in which science has determined that you can make such a showing, but we also have allowed for evidence related to adaptive functioning to be taken into account when looking at intellectual functioning. So I think what you've done is shift this to be all about the IQ.
And remember, this is the thing here is, do we just rely on the IQ? And there's a lot of argument that no, we don't, because there's a lot more besides IQ we're dealing with. And I think that's true. If you really want to find out if somebody is mentally retarded or not, there's a lot more to it than just, well, how do they answer this or how do they answer that? It's like your IQ is determinant of things besides your just whether or not you're retarded. Like there's, the statistical quantitation of your mental and of your mental disability. It's like, well, yeah, of course there's going to be other ways you can kind of gauge it. And yeah, I don't think it is wrong to have a holistic thing, because I could see like there's got to be times where you could be at a 69 and you still know what you did and it was wrong and all that. Like, I think that kind of excuses people and gives them that benefit, like gives them that like out that, hey, you're too stupid to understand what happened. And I think that creates a perverse incentive. So I actually agree with KBJ here, but I would argue the entire court's already on her side at this point. So here we go.
IQ test in a way that is not supported by our case law.
Atkins cited the 4th edition of the DSM, and I think the phrase that you just used appears in that edition, and then further defines what general intellectual functioning means. And it used to mean an IQ of 70 or below. Before that, it was 65. Now they're saying it's 75. But IQ has always been the primary criterion by which
primary, but not the sole. And we've never said it's been the sole. And what the district court did here was look not only at the IQ scores holistically, but also other evidence of adaptive functioning. And that's precisely what our case law says that the courts are supposed to do.
But Kelly says, how did I dirt my own argument? No, I agree. I think I agree with it. Like, I agree. The first element out there is, it's not just IQ. Like, what's the totality of the circumstances show? And I think it's out there. Still, it's just my client base and made him too sympathetic. Yeah, I'd rather be more sympathetic than less sympathetic in these situations.
So let me ask you, why do you think that the test should be simply and solely IQ score cut off at 70?
This is not an official channel, Ag. This is somebody who's put stuff together, probably with some AI.
IQ is originally how intellectual disability was defined as a condition, and it's always been the primary criterion, and states are allowed to take the best evidence of intelligence and to make that the test.
But what do we do with a brief of the American Association of Intellectual and Developmental Disabilities, the actual experts in this area, who say, and I'm looking on page 24 here, other than requiring the careful use of clinical judgment and professional responsibility in performing a complete analysis, there can be no single mandatory empirical method for clinicians to use in considering multiple scores or in determining whether or not someone is intellectually disabled. They look at a lot of things. So reducing this to a single score seems to me misguided.
Well, if there can be no one mandatory method, then it's up for states and their legislatures to decide. That brief also said on page 15 that IQ remains the best single representation of intellectual functioning. And the alternative is very unworkable. Courts do not have a means by which they can compare the evidence at prong 2, for example, that he struggles with navigating the subway system or doesn't know how to cook certain dishes, against the objective IQ evidence. How many
I'm sorry. I'm having a really hard time with this case because I don't think you're wrong. States can define this the way they want. The problem here is not what the state of Alabama is doing. The Alabama state is doing what all courts are doing. You haven't pointed me to Perkins or any other court where the rule that you're proposing has been adopted by Alabama. When we get that case, we might answer your question, but in the abstract, I don't know how we can answer it here. You didn't argue this below. Your own expert did exactly what you say is wrong. Your own expert said he had he had valid scores between 72 and 78, and he relied on all of the other indicia to determine that he believed this person wasn't intellectually disabled. Respondents, experts, concluded differently, and the district court credited respondents' experts. But please point me to somewhere in the record in the district court where you made this argument. In 2015, the 11th Circuit, not the order before us, determined that the Alabama courts had erred unreasonably because they had done exactly what Hall told them they couldn't do. They looked at the three scores that were extant at the time, 72, I think it was 72s and 274s or something like that. It wasn't the 78. The 78 came later. And they said on the basis of those scores alone, he wasn't intellectually disabled. And that's exactly what Hall the year before had said was wrong to do. You didn't appeal that decision. So we have to accept that the district court is now the finder of fact. And if the district court is the finder of fact, it can do exactly what you're saying. Follow Alabama law and show me one case in Alabama that has followed your rule. Tell me where in the trial record you argued that somehow aggregating scores, that somehow medium scores, that somehow there was one perfect IQ score that states could require. Just show it to me. Point me to the record.
Respectfully, Your Honor, at the start of your question, you asked, what is Alabama law? And I say Perkins says it's an IQ of 70 or below. And you implied that.
But how do you prove that? And Alabama courts do exactly what the district court does here. It looks at the SEMS. That's what the court did here. It then decides whether the person is within the range of intellectual disability, which the court did here. The SEMS certainly are at least 3 out of the 5 are within disability. And then it looks to other things to determine whether the person's intellectually disabled. It's exactly what we told people to do in Hall. It's exactly what we told people to do in Moore. What you're asking us to do is to undo those cases, because both in Hall and in Moore, there were various scores, just like in this case. In Hall, there were 9 scores between, what were the figures? 9 scores between, I can't remember now.
71 and above.
Not much, even worse than here, between 71 and 80. Here, there are 5 scores between 72 and 1 score of 78. And in Hall, only one of the lowest scores fell within SEM.
So
here there were 3.
I'd like to clarify first Alabama law, because in Your Honor's own description of what the state courts did in this case, they relied on the scores of 72, 74, and 75. And now they have
without looking at the SEM. And we in Hall the year before said, you have to look at the SEM. They didn't.
We've cited multiple Alabama cases, Bush, Byrd, and Kalin, all of which had similar scores to Smith's here.
If you read every one of those cases, the courts there did exactly what this court did here. They looked at all of those scores, then they looked at the adaptive functioning to determine whether the person was actually at the lower end of the score or the higher end of the score.
The state courts have...
Can you dispute that that's what those courts did?
In some cases, the courts do look to other evidence, but they don't grant an Atkins claim based on that other evidence. There's not an Alabama case in which an offender was known to have an IQ above 70 and yet won his Atkins claim. And there's certainly not an Alabama case in which the courts plussed the lowest score alone and said that represents a possibility of intellectual deficits and moved on.
That's not what happened here.
That's my question, counsel. I wanted to know about the Alabama law, too. Could you just precisely explain, I don't want to delve into the record in this case, so my question is a little bit different from Justice Sotomayor's. I just want to know what is the Alabama rule, because it seems to me that Justice Sotomayor is right that there are some Alabama cases that do move on to adaptive functioning. And so what about the other indicia, and what role do they play in Alabama law?
I think since Hall, courts have been confused in Alabama and nationwide about what some of the dicta in Hall means. I mean, with all due respect to this court, there are some confusing lines in Hall to interpret and apply in these cases with multiple scores, if Hall applies at all to cases with multiple scores. And so the Alabama courts are grappling with that too. And they say, well, we looked at everything. We looked at the whole record. But there is not a case in which that other evidence has ever trumped IQ in Alabama. And what Alabama wants to do is best exemplified by its pre-Hall case law, such as Ex parte Smith, in which a 72 seriously undermined the Atkins claim.
But I'm confused because it doesn't seem like Alabama prohibits the court from going on. So if a federal court is trying to figure out what the Alabama law is, wouldn't a federal court be justified, say, if we remanded it to the 11th Circuit in considering factors beyond the IQ scores?
Well, I think the best evidence of what Alabama law is how the courts applied it in this case. I think at the end of the day, this court has to determine what is the federal constitutional minimum, what's the floor for Atkins claims.
Counsel, isn't, I mean, with respect to Alabama and its law, whatever it may or may not be, can a federal habeas court grant relief without finding a violation of federal law or the federal constitution, in this case, the Eighth Amendment?
No. And that matters quite a lot.
So what matters is he intellectually disabled? That's the federal law, right?
The federal law is Atkins.
That's a very interesting thing here. The judge is like, so if there's a habeas corpus is used as post-conviction relief for prisoners at the federal level. So state court prisoners will use habeas corpus petitions as a means of attacking their sentences, a means of attacking their court case. Habeas work at the federal level is a very specialized thing. But one of the things this guy's doing is challenging his execution through habeas and challenging under the Eighth Amendment. So that's why we're getting here where we get this. Why are they not focused on when and where they'll attack again? Okay, well, Jesus. You guys are ridiculous. You guys are ridiculous right now. And Chairman Lamau says the perfect IQ is 139. This is known smart, but not too smart. Actually, it's when you get up to like that high, being at like that high, I mean, it's not 140, but being up there, that's pretty tough. Being that high, being on the high end of the scale is almost as bad as being on the low end of the scale. People in the super high end generally poorly function in society. They aren't able to have relationships. They aren't able to conduct themselves. It's limiting in its own way. It's limiting in its own way. So I don't think you'd want it. Like people think it, like, I don't think you really want to be that smart, because somebody's 139 or 140 talking to me would be like me talking to the guy who's at an 80 IQ. I'd be like, holy shit, this guy's fucking retarded. That guy would be the 140 guy would be talking to me saying, holy shit, this fat guy's retarded. It's a prison of its own. It's yet a very remarkably similar prison. So I don't know if I'd want an IQ like that. Sellers saying, SP Sellers saying, it's still arbitrary, no functional difference between 69 and 70. Yeah, but you have to have a cutoff line. You got to draw a line somewhere. You got to draw a line somewhere. I mean, is there really a difference between 0.79 and 0.81 and 0.079 and 0.08 and 0.081? No. But you got to draw a line somewhere. Got to draw a line somewhere. And Spud Gun for £2 sterling. The King Sterling says, do they lick windows? These guys might. These guys might. You don't know. They might. So would I rather be smart or attractive? Well, I'm not attractive and I'm not smart. So I didn't get either of them. I didn't get either of them. Chairman Lamau says, I tested at 139 when I was younger. I'm not that smart anymore. Well, yes, as you get older, your IQ, you always lose a little bit. You're still fun, Sean. Well, thank you. I try to be. Let's see here. Let's see. Yeah, I'm trying to see what you guys are. Anything else? Is KBJ retarded? Seriously? Her line of questioning sounds retarded. I'm serious. It's not funny. Well, I'm not worried about her, but the rest of these courts are like, well, they had to ask him. So, like, what is Alabama's rule? And can we rule that it violates the Eighth Amendment? He's like, no, because we're following the rules. It's very interesting here. Let's keep going, though. So let's keep going. We'll rewind this just a hair because I think it helps you guys to understand kind of where we're getting here a little bit. Actually, we'll go back a little bit more. We'll go back about a minute.
Prohibits the court from going on. So if a federal court is trying to figure out what the Alabama law is, wouldn't a federal court be justified, say, if we remanded it to the 11th Circuit and considering factors beyond the IQ scores?
Well, I think the best evidence of what Alabama law is how the courts applied it in this case. I think at the end of the day, this court has to determine what is the federal constitutional minimum, what's the floor for Atkins claims.
Counsel, I mean, with respect to Alabama and its law, whatever it may or may not be, can a federal habeas court grant relief without finding a violation of federal law or the federal Constitution, in this case, the Eighth Amendment?
No. And that matters quite a lot.
So what matters is he intellectually disabled? That's the federal law, right?
The federal law is Atkins and Hall.
Exactly. That you can't execute an intellectually disabled person.
What is your understanding of the role of state law in making that determination, whether Atkins and Hall leave discretion to Alabama in defining what intellectually disabled is? That's my question. Obviously, it's an Eighth Amendment question, but what is the relationship between the Eighth Amendment and state law on this question?
So for Atkins, page 317 said that to the extent there's disagreement, the states have disagreements about who qualifies, who is in fact intellectually disabled. And so there's some suggestion in Smith's brief that the state's discretion extends only to procedural or evidentiary matters. But I read that paragraph in Atkins to mean that states actually have leeway as well in defining intellectual disability. And the definitions change. One reason states need discretion is that the line used to be 67. AAMR at one point put the line at 85. Now it's 70, or maybe it's 75 or somewhat above 75. And so states are not required to divine from these different psychiatric manuals what the best possible science could be when they're making a legal determination of intellectual disability.
Let me posit this to you, that Atkins was trying to give states a little leeway because Atkins was, it was a strong new holding from this court, defying new ground. It was trying to give states some leeway. But at the end of the day, a federal habeas court cannot grant relief on the basis of a violation of state law.
Correct. States can be more lenient, but that would not be a ground for federal habeas relief. Smith
You have
has
to
an
find
Atkins
that
claim.
there is an actual Eighth Amendment violation in this case.
Correct. Smith has an Atkins claim, not a Perkins claim. And Alabama is not more lenient than Atkins. Alabama is not more lenient than Hall. Alabama is trying to enforce the
It
constitutional.
would be rather surprising to hear Alabama come in here and say we're more lenient
Correct.
than what the court is requiring us to do.
Absolutely.
It could happen, but it seems unlikely.
Not in this case.
And under Atkins, what do you think about? Because I'm sorry, the time's.
And that's something you guys need to understand. A habeas corpus petition is at the federal court level. You're challenging federal constitutional challenges to your conviction, not state law, but federal law and and constitutional challenges. So.
No, please continue.
You're asking about what the Eighth Amendment. What do we do with our precedents in this area? What if we said under Atkins, states can implement prong one however they want, because that's what Atkins says, as long as they don't treat a single score in the low 70s as decisive. Hall, and two, don't use extraneous facts to IQ scores to outweigh a low score more.
I think that's correct with one caveat. It's not just a low score in the low 70s, but it has to be a score that has an error range, and that could be one standard error of measurement, according to the APA's brief in Hall on page 23, that includes 70 within its span. So that's how I would read Hall, but yes, those two rules are how we read the precedents.
Thank you.
Thank you, Counsel. Justice Thomas? Justice Alito?
No.
Justice Sotomayor?
My understanding, this is somebody independently doing this. This is not an official government channel.
I don't see any state that defines intellectual disability this way. I certainly don't see, or to prove it this way, I don't see anything in Alabama's law that suggests it's following that rule. You're making something wholesale up. And you're claiming that there's disagreement in the lower courts. I don't see all that much disagreement. In Smith's table on page 17 of the appendix, he has cases from across all the states. And although you try to reap some confusion among them, they all seem to be following the method the district court here followed. And we announced a new rule. We've announced more confusion into an area where there's pretty standard procedures. They do exactly what the district court did here. I have no case that I have found, and I want you to find one state case that applies the rule as you've articulated it.
Byrd versus State. clearly states that the offender has the burden to prove by a preponderance of the evidence that his IQ is 70 or below.
There is no dispute about that. Assume I take that as a given. We didn't grant cert on that because that really wasn't disputed anywhere. So where's the rest of what you're saying? That states determine prong one based solely on IQ scores and some statistical unknown method of creating a medium composite score.
There are different methods. Some state courts have taken the average or the median, or they've simply said the scores are consistently above 70, and so it's an offender's burden to come back and overcome that with a statistical method. It's not Alabama's burden.
Name one court that has held that it's up to the defendant to prove the first prong by a preponderance of the evidence with some statistical measure. It's not what I see. I have not found one state case that has required that. And now you're going to put in a new requirement that's actually even more complex than what states have been doing.
Well, Hall itself said that evaluating multiple scores is a complicated endeavor.
I am asking you for a simple answer. Name one state case that has made your prong one dependent on a statistical analysis of what somehow either an aggregated, medium, composite, I don't care what word you use, one state case that has required that.
Well, I think courts haven't needed to go that far because offenders haven't come with a method. They haven't satisfied their burden in these cases.
But they have granted relief to others without it.
Not in Alabama. Sometimes the 11th Circuit will do that, applying this lowest score rule. And there is a division of authority. The 8th, 9th, and 11th Circuits look at the lowest score alone and say that it
they may well be wrong. And I think I haven't looked at those cases carefully enough to say whether they made error or whether you're characterizing them in a way that's not quite accurate, like here. The 11th Circuit made clear, as did the district court, that it wasn't relying on just the one low score. There were 3 scores that were within the same of 70 and below.
Hall said that IQ is a measurement that has statistical properties which we can evaluate, and that's why we take into account the standard error of measurement. The experts in this case are also telling us.
One case that has required plaintiffs to come in with the statistical mathematical certainty of a particular number.
Not certainty, but a preponderance of the evidence. And
thank you, counsel. Your answer must be
Justice Kagan.
Mr. Overend, I guess when I read Hall and Moore, I come away with a couple of things that are relevant here, and then a lot of space for the state court to do what it wishes, including with respect to multiple scores. But here are the 2 things that I take from Hall and Moore that are relevant here. The first is that in looking at any given score, you have to take into account the standard error of measurement, right? So that a 72 with a standard error of measurement of 5 becomes a 67 to a 77. And that's one thing that they said, right? You can't just treat it as above 70 because you have to recognize that SEM. I don't think you disagree with that.
Except for the 5. Correct. Courts have to take into account standard error, but it's not always 5.
Of course. I'm just using that as a hypothetical. All right. Yes. The second thing that it seems to me come out of those 2 cases is when you have a score, and most of these cases, you're going to have, almost all of them, you're going to have multiple scores. But when you have one score, because in both of these cases, they just treated that low score as dipping below the 70 or a 70 or below, that gives the defendant the opportunity to come forward with adaptive functioning evidence. It's just an opportunity to come forward with that evidence. Now, at that point, and this is true of a state that does the whole thing holistically, it's also true of a state that breaks it up into prongs. At that point, a court can decide how that evidence compares to all the other evidence in the case. And if it's a multiple score case, where it's only one score that's dipping below 70, of course, the court can say, there are 5 other scores that are above 70. And we think that that's highly probative. So, it's very nice that he had the chance to come in with adaptive evidence, but that's not going to play in our analysis because we look at all the scores and the scores alone do it for us. I think a court is definitely allowed to say that after Hall and Moore, as long as they've given a person the opportunity to come in with adaptive evidence. But they're also allowed to take into account that there are a lot of scores that suggest that the person is not intellectually disabled. So that's what it seems to me the law is coming out of these two cases. Do you agree with that, or do you not agree with that?
No, I don't agree with that because Hall didn't answer the question of what to do with multiple scores. And so if
it didn't, and because it didn't, that's why I say it really does leave a lot of discretion to a state court to decide how it wants to deal with the fact that there are a lot of scores on the plus 70 side and not a lot on the minus 70 side. That's totally within a state court's discretion to say there are a lot of scores here on the plus 70 side. That's dispositive for us. As long as they've given a person, this is the only requirement, it seems to me, that comes out of Hall and Moore. They have to give the person with the 70 or minus score the opportunity to come in with adaptive evidence suggesting the opposite.
That would be an extension of Hall, and we've said that Hall should not be extended.
I would have thought that that's just what it says.
If it's reasonable for a court to do that on a set of facts, then it should also be reasonable for a state legislature to say the true IQ line is 70, and that can be dispositive. So if a court could do that with a scores of 72, 75, 76, why couldn't a legislature do the same thing and say, no, we don't want to leave that door open because we don't trust trial judges to do this well?
Yeah, but I think that is the difference, right? That Hall and Moore did say, you have to give the person the opportunity, you have to put it in front of the judge for the judge to say, this is a case where I'm not convinced, there are 5 scores, but they're all hovering around the 70 mark. As compared to a case where there are 5 scores and most of them are nowhere near the 70 mark. So you have to give this person the opportunity, once you have that low score, to say maybe it's that low score that should be, that is more reflective of the person's intellectual function.
There's more we can do with IQ, and the experts are coming in and agree with us that there are ways that you can combine the scores. And so the offender's at least got to do that and at least has to show a likelihood below 70. If there's a case where it's truly indeterminate, and that's what Hall seemed to think, that a score of 71 is so uncertain standing alone. If there were a case that's truly indeterminate, then perhaps there could be other evidence of intellectual functioning, not adaptive behavior, certainly.
I don't think that they thought it was indeterminate standing alone. I mean, both Hall and Moore are multiple score cases, and both were perfectly aware that they were multiple score cases and talked, as you said, about the difficulties of dealing with multiple scores. So they knew that they were talking about multiple score cases. And the requirement that they set up is still, if you have one score that brings you into the 70 minus range, that's enough so that you have to you have to open the door to a person's evidence. Now, that's not to say you have to accept that evidence for a moment if there are a whole bunch of scores going the opposite way.
But we know what happens in these cases is that courts don't weigh the IQ evidence. They don't say, well, the IQ evidence is really strong for the state. Let me weigh that against his inability to buy car insurance or to maintain a bank account or something like that. They simply move on from IQ. And so once you open the door to this kind of balancing test, the second prong is really malleable, really.
And chat, that's, if you were wondering kind of, and I probably didn't explain this before, how do you gauge what people can do? Well, it's life skills. Can they interact? Can they order? Could they go to McDonald's and make an order? Are they too stupid for that? Are they too intellectually disabled? Because there are people who can't do that. If you said, hey, go get a cheeseburger, like, they could tell you what they want, but there's no way they could do it. It's basic life skills. So, for example, a lot of kids, wherever you live, if you have a developmental disabilities board and they teach people life skills, like they're teaching them how to interact in society because we have to teach them how to handle these things. You can't figure out the kiosk, but yeah, okay, well, that's kind of what they're getting at here if you guys don't understand what's going on there. And Lucky Lime says, do people actually believe IQ is in any way practical, useful for anything? I mean, to sit here and argue it's got no use at all is just as preposterous. I mean, we have to classify people and organize them. Yes, IQ tests are helpful for that. Are there other things you need to use as well? Yes, but it's a good basic measuring stick for some things. Should that be all you do? No, but to sit here and argue you can't use it, I think it's a bit goofy in that regard. So, well, Kill Yourself Leader, I think, is saying for $2. A good question. Could someone with an IQ below 70 even be tried? Yes. Remember, it's the competency standard, and the competency standard is, and Clyde, I'm going to set you, by the way, guys, we got Clyde. We have Clyde. Let me sneak it in here. Think about it. The standard for competency is not a specific threshold. The standard for competency is not a specific threshold. It's, do you understand what's going on in your case, and can you assist your counsel in a meaningful way? Can you actually help them? Assist in your own defense. If the answer is yes, well, then that's it. So, yeah, it's actually not like if you were hoping there was something there. No, there's no magical thing. Now, yes, at a certain point, a court might say, okay, yeah, if somebody's got like a 40 IQ, okay, maybe. But I would say after some point, it's like, could you even constitute enough mental capability to actually do positive offensive action? So no, just having a 69 IQ would not automatically exclude you. It would be a significant thing to overcome for the state to say this guy's competent, because how the hell am I going to work with a guy who's got a 69 IQ? I probably can't, but it's not automatic. I'm going to have to demonstrate that I can't. It's a very good question, though. It's a very good question. And thank you for the $2 super chat. And then Luke is saying, isn't someone with an IQ that low being in a position to be charged with a crime of failing on our part? I can see yes and no, that like this person was out there unsupervised. He's put into a situation where he's out on the street interacting with people, and, you know, he had a chance to be violent. Sure, there could be times where, yes, as a society, we screwed up by letting him out. But at some point, you know, he is a grown-ass man still, and you know better than you don't hit people. Even a 69 IQ guy could figure that out. So at times, yes, I agree. Do we set people up to fail? Sure, we certainly do. But is it ultimately all him? No, I wouldn't say it's ultimately all his part. Ultimately, not all his part. At least that's how I'd explain it. And then Shredder S07. But remember, for 18 months says, my super chats keep getting blocked. I am sorry, that's YouTube. Not sure what's going on there. Move my light out of the screen. Oh, sorry. I didn't realize I was... Sorry. I mean, that's kind of where we are with that. Let's see. What else are we saying here? Bella's saying you never scored below 70. I understand, but really, do you think a guy who scores 72, like, it's all of a sudden I'm going to be like, oh, wow, I'm dealing with, like, fucking Chaucer? No. Sorry, I didn't realize the light was like in the way like that. My bad. We fixed it. Sorry. So it's is it the best thing for all parties? I agree. So let's keep going though.
Amorphous, and we're picking up disparate facts about someone's life, self-reported or by biased reporters. And so that evidence is not disciplining the inquiry. It's not adding more rigor to figuring out what the intelligence is. And if it were, then the IQ specialists would simply make a better IQ test that accounts for things like that.
Okay, thank you.
Mr. Swisich? Mr. Kavanaugh?
So what are the different permissible Eighth Amendment approaches a state can use when there are multiple scores? For example, in your reply brief, you articulate if the median is above 70. Is that, if the median's above 70, can the state say that's it?
That's a good question.
Yes.
Okay.
So what is
and you don't think Hall and Moore require more analysis in those cases? You think that's a safe harbor, so to speak?
Yes, states can adopt reasonably reliable methods, and the APA handbook says that the median is option 1.
Okay, and if another approach you articulate is the overlap approach, the overlap among each score's error range, same question there. If the overlap, you're a little bit ambiguous about what the overlap needs to be to give you certainty. What you want to explain that? I know you think it's satisfied here, but what's the rule?
So the idea is that when there's a cluster of scores, that we can take into account each score's error range and then lay them on top of each other and see which numbers the error ranges have in common. So the intuition there is that maybe his true IQ is somewhere in the middle.
What if the bottom of the error range is 69 or 70 of the overlap error range?
I don't think that's a problem for the state because the question is still the likelihood that his IQ is 70 or below. So simply having the number 69 in an error range, whether using the overlap or some other method, doesn't reflect a greater than 50% chance that his IQ is below 70.
But in any event, in this case, you say the bottom of the overlap is 73, I believe, correct? At least that's what you say in the reply brief. You say 73 to 77.
And I think that should be a 78, but...
Oh, sorry, chat. Hold on. Sorry. I just missed that. But you can see where there's pointing out that the overlap and all how this is all going to work. It's like, well, wait, if it's at 72, that means 69 is possible. And he's saying, well, yes, statistically, yes, but the likelihood is that it's actually 70 something. So, anyways, we'll go back to this guy. Sorry.
That's on the most generous assumption about the error range being plus or minus 5.
Okay. And is the composite score method another method that the state can use, and in your view, stop there?
Yes.
Okay.
When it's available.
And are there any other methods?
The average is a rough approximation of the composite score.
Well, there's a lot of skepticism about the average being accurate.
Well, the author of the AP, one of the authors of the APA's amicus brief in this case, Dr. Schneider, said that the average is a rough approximation of the composite score. Even if the composite score is the theoretically best method, states are allowed to adopt other methods. The fifth method would be to look at the high score when the highest score's entire error range is over 70. And those are the 5 that we've discussed as reasonably reliable methods.
And why there? This picks up on the Chief Justice's question, but why are you picking just the high score in that fifth approach?
The highest,
it seems, as he said, result-oriented.
The highest score is more probative because there are many ways that an IQ score can err downward and very few ways that a score can err upward. And so especially to take into account the obvious incentive to malinger in these cases, the lowest score should be viewed with greater suspicion. Oklahoma has adopted a rule like this and has withstood federal review for many years.
And follow up on Justice Kagan's question, what's the logic or the rationale or the sense behind not having a district court or a trial court or state court have the ability in those circumstances to go on and look at more? Because I think what you were saying is each of those approaches are essentially a safe harbor. You win. The defendant can't meet his or her burden in those circumstances. You win. The state court can't go on and look at other things. That's, I think, what you're saying. What's the logic, the rationale, the sense behind that?
Well, the adaptive behavior prong is simply not as good as IQ. And so once you start weighing that subjective and amorphous evidence against the objective evidence of IQ, we don't think it's within courts' capacities to do that well, even if clinicians could somehow weigh the evidence of the ability to buy groceries against the IQ score of 78. I don't know how courts would do that. Adaptive behavior was added later. Originally, the diagnosis was just based on IQ. There's great disagreement among the experts about what adaptive behavior even means. Is it 10 or 11 domains or 3 different domains? And there's great disagreement about how to even measure it. There are hundreds of different scales, inventories, batteries for adaptive behavior. I think people have a misconception that these are just other standardized tests, but often it's not, and there's a lot of judgment that goes into picking them. So I'll just give one example in this case, a reading comprehension test. The courts below credited evidence that that Mr. Smith is barely literate, I think at Petition Appendix 22, and then he was administered a reading comprehension test that showed he reads at an 11th grade level, which is clearly inconsistent with intellectual disability, but the state courts focus on the evidence from grade school, they pluck out a different fact. And so this is not a really rigorous scientific test. The way that IQ is the fruit of a multi-century enterprise to figure out the best possible estimate of intelligence.
Thank you.
Justice Barrett, Justice Jackson.
So I guess I'm trying to understand the basis for our being able to determine that the district court in this case erred, which is what I understand you to be asking us to do. So are you saying that Alabama has selected any one of those 5 methods by legislation, for example, and the district court refused to apply it in its consideration?
No, Alabama hasn't adopted one of those.
All right, so you explored a number of possibilities with Justice Kavanaugh, none of which Alabama has actually adopted, so we can't say that the district court erred by not applying Alabama law in that sense. Did you ask the district court to apply any of those methods in its consideration of this defendant's intellectual disability?
It's the petitioner's burden to come in.
No. Did you? Your burden right now as petitioner is to establish that the district court erred. And so what I'm trying to ask you is whether you are saying that the district court erred by not evaluating this defendant in a way that he was never asked to do by the state below?
Well, it's a legal error because my answers to Justice Kavanaugh were that those are all reasonably reliable methods that the state could adopt. And if that's true, then it doesn't matter whether Alabama has in fact adopted them in statute because there's no Eighth Amendment
That was my
violation.
first question. Doesn't it matter for the purpose of our evaluation of the district court's error whether or not the district court was asked to evaluate this defendant using the method that you now say it was erroneous for the district court to not have used? This never came up during, no one said to the district court, please evaluate him using this method, and the district court said no. In that situation, we then assess whether the district court was wrong in refusing to adopt that method.
We didn't get that far because we had 5 IQ scores that clearly show he loses, and then the district court focused only on the 72. And so the question—
The district court was weighing all of the evidence under the standard that it seems like your expert also agreed was the right legal test at the time. And now you're saying the test should have been different. The district court was only allowed to look at one of these other 5 reliable methods, although no one said to the district court at the time, please look at that method.
We said to the district court, Alabama law is a true IQ of 70 or below by a preponderance, and then the district court did not apply that burden.
Okay, let me ask you this, because I do think that there's something about party presentation here that's a little troublesome. A couple weeks ago in a case called Clark versus Sweeney, we summarily reversed a grant of habeas because the Court of Appeals had granted habeas based on an argument that the petitioner had not.
Chat, remember, the issue of party presentation is what arguments did you present? Those are the ones we're going to rule on. So the court's going to that too. It's your audio's all clicks and whistles. Jesus. Johan, thank you for $2. God. Yes, this is Ketanji. This is Ketanji Brown Jackson. Somebody's asking here. The Alabama Supreme Court addressed the state law portion or not touch this? No, they said we're doing it the right way. Ultimately, Alabama, when they dealt with him, said we're doing it the right way. Remember, this is a challenge through federal habeas. So federal habeas, guys, is not you go to your state supreme. And this is if this isn't clear. When you're doing federal habeas stuff, you don't start at the Alabama trial court and you work your way through the Alabama courts, and then you start at the federal court level and go to the top. No. In habeas court, in a habeas petition, you go to district court, federal district court, then you go to your circuit court, and then you go to the Supreme Court. So this is an entire federal track. The Alabama courts have done their thing. It's already been done. It's dusted. Alabama thinks they're good to go. 100% Alabama thinks they're good to go. Habeas is you using the federal court system and trying again on federal claims. So that's the difference. Well, she's asking about the state laws. Yes, because the state laws are being Joseph Smith is arguing the state law and how they apply the state law violates the 8th Amendment. So that's why the state law is there. That's why they're attacking the state law. They're attacking the state law on 8th Amendment grounds. That's the entire premise of this, that it's unconstitutional the way you applied this, therefore you can't execute me. That's what they're going for here. Does that make sense?
Had not presented. So I feel like you're actually asking us to violate that same principle. You never asked the Court of Appeals in this case, for example, to evaluate the district court on the basis of these 5 methods and say that it was erroneous on that basis or on the cumulative effects test. I'm a little confused all around because I thought the question presented in this case was about the cumulative effects test and that's what you were actually advocating for, but that didn't come up in the lower courts. So how could we possibly reverse on the basis of these kinds of arguments that were not presented below?
We absolutely did present evidence from Dr. King at JA 270 and 271 that his consistent scores were above 70. We didn't have to get to the level of granularity of specifying a particular method because there is no method in this case that can prove his IQ is likely 70 or below. We're offering those to answer the court's question how to assess multiple IQ scores.
And your answer is not something about cumulative effects is what the court had to do and didn't do. I thought that was the test that you were requiring us to consider as the thing that a district court has to do.
Our first argument is that it didn't do that because it looked only at the possibility. And if the court agrees it has to do that.
I'm sorry. I thought you were saying the district court erred because it didn't consider the cumulative effect of multiple IQ scores, and that the cumulative effect was a thing that the district court didn't do. All I'm asking here is, did you ask the district court to do that? Or did you say to the Court of Appeals the district court has erred because it didn't look at the, quote, cumulative effect of the multiple IQ scores?
Yes, we said that in the district court with Dr. King's testimony. We said
cumulative effect. I'll find it in the record. Because I didn't see the words cumulative effect in the record.
Well, there are lots of synonyms, but consistent scores above 70, that's the same thing. And then the 11th Circuit, we presented this evidence and said the district court didn't take seriously the whole of the IQ evidence because it didn't even mention his score of 78. So it couldn't have done the cumulative effect. That's enough to reverse. If the court wants to go further and discuss the reasonably reliable methods, we think that would be a good idea, especially for guidance.
So you're not asking necessarily for that rule about the reasonably reliable methods that certainly did not come up before.
Well, that is the question presented. And so that it would be a complete answer to Smith's claim is that there is no way that he can prove an IQ below 70 because even on these common and expert approved methods, he hasn't shown that his IQ is below 70.
Thank you.
Thank you, counsel. Mr. Graver?
Mr. Chief Justice, and may it please the court. Under Atkins, states have significant discretion in defining what it means to be intellectually disabled and what a defendant must do to prove it. Alabama has exercised that discretion to require that respondent show his true IQ is likely 70 or below based on all relevant evidence, including his multiple IQ scores all above 70. The courts below erred because they replaced that burden with some variant of a one low score rule. Everyone now agrees that such a rule is wrong. Instead, respondent focuses on justifying the opinions below as applying a holistic analysis, but that misses the point. The problem here is not that the courts below simply looked at other evidence. It is that they measured that evidence against the wrong standard, and it's that they looked at that evidence on only one side of the scale, never considering the collective weight of respondents' multiple IQ scores taken together. I welcome the court's questions.
What exactly did Atkins say the Eighth Amendment violation was?
I think Atkins laid down a general rule, which is that you cannot execute the intellectually disabled, and the meaning of intellectual disability is something that states define with significant discretion.
What did Atkins say about determining what intellectual disability meant?
Real quick, guys. Hold on here. Mweezy. So the first guy he was for the state of Alabama. So that's perfect. Obviously, they're saying we did a good job. Let's execute this son of a bitch. The second party, and first off, it's John Hamm, not the actor, but John Hamm is the director of the Alabama Department of Corrections, okay? He's the petitioner here. He's suing because he's saying the 11th Circuit got it wrong. What's happening here is the United States, remember, the U.S. government has that unique ability. They get to tag in whatever they want to and say, hold on, wait. Yeah, I'm the Solicitor General. I want to speak on this. I demand time. You know what the Supreme Court says by the rules? You got some time. Harry Graver is here on behalf of the Solicitor General and the DOJ. They're supporting the state of Alabama. There's like 30 states that support Alabama right now, and they want to be able to execute people. Joseph Clifford Smith's attorney has not gone yet. That's the next guy to go. So I hope that explains. No, they're saying that they've done a good enough job. Both these guys are going to say what happened in Alabama is good enough. The law is legal. It doesn't violate the Eighth Amendment. The way the law got applied does not violate the Eighth Amendment. Therefore, it's all good. This guy's saying it's good. This other guy's saying it's good. And you'll hear when the other guy gets up there, the third guy that goes, his name is Seth, you'll hear him explain how this is all garbage and bullshit. You just got to give it some time to get there. So I hope that clears things up for you. I hope that clears things up.
I should use the word retardation.
Sure.
What did it say that was?
I think that Atkins and the Chief Justice put this well in Moore, is that the scope of Atkins reaches no further than the consensus of the states. So I think that to the extent there's content to that command, it's going to come from state consensus. But I really do think that Atkins largely, much as this court has done in the insanity context, outsourced the definition of intellectual ability to the states.
Counsel, I'd like to, you're focusing in on Atkins, but Hall and Moore say something very different than what you're saying. In Hall, Mr. Hall had scores between 9 scores over 40 years. The lower courts found a score of 71 and 80, only 2 of the scores to be valid. But Florida had a strict cutoff rule that said anyone with higher than a 70 could not be intellectually disabled. So you can't have a flat rule that says you get one score over 70. You're not disabled, correct?
Correct. I think that
And what Atkins also said, I'm quoting, for professionals to diagnose and for the law then to determine whether an intelligence disability exists once an SMN applies and the individual's IQ scores is 75 or below, the inquiry would consider factors indicating whether the person had deficits in adaptive functioning. Courts must analyze the STEM, and if the STEM includes 70, the defendant must be able to present additional evidence of intellectual disability, including testimony regarding adaptive functions. So for us to say what petitioner wants would disavow that language in Hall. It would disavow nearly the identical language in Moore. In Moore, he had two valid scores of 74 and 78. Nowhere did we suggest that courts had to aggregate, accumulate, medium them out, composite them, do anything else with them. What we had, and there the court held that the state courts had violated Hall when it discounted the lower end of Moore's STEM because he was malingering. The tests were valid, had a STEM, the STEM was below 70, and then the court held, once the STEM in some of those valid tests were below 70s, courts, quote, must continue the inquiry and consider other evidence of intellectual disability where an individual's IQ score, adjusted for the test standard error, falls within the clinically established range for intellectually functioning deficits. So you are asking us to tell courts below to do something substantially different than what we told them to do in Hall and Moore.
Respectfully, no, Justice Sotomayor. There's a big difference between saying you can move on and look at other evidence and saying you can then forget about IQ entirely. The big problem here.
Okay, that's something different. What you're talking about then is not a legal error by the courts below. You're talking about your difference of opinion.
No, it is a legal error twice over, and I think it's a helpful thing to spell out here, is that even if you look at other evidence, you still need to circle back and see how that weighs against the evidence on the other side of the scale. And in this context, that is going to be the multiple consistent IQ scores together. The two legal errors.
But that's what the two experts, the three experts here did. There was Dr. King, I think one was Dr. Cuddy, who was the original expert, and then there was the evidentiary expert, Dr. Fabian, if I'm not mistaken. Each one of them did exactly that. Your Dr. King looked at the scores and said, I'm looking at the functioning, and I don't think he's on the lower end of 70, because when I speak to him, he speaks well, he can respond, I think he functions at a higher rate. The other doctors, which the district court credited and did many, many more tests than Dr. King did, looked at all of the tests, all of the results, and said, I'm convinced that his range is 70 and below.
So before turning to the experts, let me just emphasize what I think are two discrete legal errors with the way in which the courts thought about this under Alabama law. Even if you tend to look at the secondary evidence, you still need to circle back.
Are you saying it's wrong to do it? Do you say Alabama says it's wrong to do that?
Wrong to do what?
Look at secondary evidence.
I don't think there's any per se rule in Alabama that says you cannot look at this, but the difference is.
So there's no per se.
Please tell us what the two legal errors are. Thank you, Mr.
So the basic idea is where you have all of this evidence together, are you measuring it against the right standard? So one legal error that happened below is that the court swapped essentially a preponderance burden with a possibility burden. But the other part is even putting that to the side, the difficulty is that you still need to figure out what the ultimate question Alabama law is asking here, which is this other's evidence strong enough to drag down the collective weight of IQ below the line?
Totally right to me. So I'm wondering, you heard the question that I asked Mr. Overing, and I'm wondering if we disagree at all. If I say the thing that Hall and Moore require is that when you have a score that's 70 or below, you do have to give the defendant an opportunity to come in and to talk about adaptive functioning. But having given the defendant the opportunity to talk about adaptive functioning, yes, of course, you can go back to the scores and to the fact that there are a lot of scores on one side, the upper side of 70, that make you think that evidence of adaptive functioning just cannot possibly carry the day. Is that what you're saying, or are you saying something more than that?
I think I agree with 95% of, or at least with one or two asterisks. And let me say how I think that cashed out here, and then what the constitutional rule is for how you just think about IQ. The issue is that what you were describing before just did not happen here. The only time that the courts grappled.
Okay, so I take that point. Let's presume that I don't care about it for the moment.
Fair enough.
You know, that all I'm trying to do is to figure out the rule, and then we can go back and say whether the court did it or not do it.
So I think that the part where I disagreed with what you said before is just in the sense that a single low score in all circumstances, no matter what, will always preclude a state from being able to focus on IQ. So imagine, for instance, just a case.
No, I don't think it would. The only thing that I think a single low score does is to say, yes, at that point, the defendant does have to have the opportunity to come in with adaptive evidence. And I take Hall and Moore to have, that is their holding.
Right. So I think I take it slightly less categorically than you do, which is just to say, so you imagine a case of, 10 85s and 172. The collective error range of those scores, even if you look at the 95% confidence interval, is not going to grace 70 or below. So imagine a situation like that where I think you can structure it where the possibility remains
okay, so
low.
that's like the hypothetical that you gave in your brief, like there are a lot of 90s, and I kind of take that point, right? Because like at some point, there's no clinician in the world who's going to say that just because you have like one outlier score, that there's a possibility, right? If you have like 6 90s and a 72. But if you have something that's more along the lines of here, right? Then I take it that we are in agreement. Tell me if I'm not, that at that point, the Hall and Moore ruling is you have to allow the person to come in with adaptive functioning evidence. But of course, may I, Mr. Chief Justice?
Sure.
But of course, you can say this is outweighed by the fact that there's a multitude of scores on one side.
Yeah, I think that there is broad, and if I can just stress that the two key points of agreement is that moving on doesn't mean you're done. It involves circling back to the standard that state law imposes. And I think in turn with that, it's helpful to clarify what I think is now a point of agreement, that the one low score rule reading of Hall and Moore, where prong one is satisfied substantively, so long as you have one low score, is wrong.
Right.
Yeah.
Okay.
Thank you, Counsel. Justice Thomas? Justice Alito?
Let me see if I understand the colloquy you just had with Justice Kagan and the degree to which you agree with what she said.
EDW, you're saying, why did she just ask for permission? Her time was up. Like, you're supposed to go in order, everybody gets asked questions, and then they can interrupt and stuff, but, like, Roberts is, like, to her, so that's more of what we're into there.
Did either Hall or Moore hold anything with respect to how a case must be treated when there are multiple scores? Hall and Moore talk about one score, and they say that dealing with multiple scores is a complicated matter. But do they say anything about how a court is to deal with a situation where there are more than one scores?
No, not expressly.
So if there is a case with one score and the standard error of measurement has a range that is below 70, and that's it. That's all that's in the case. One score, standard error of measurement is below 70. Yes, Hall says that allows the prisoner to proceed with evidence about adaptive functions. But it doesn't say how the court is to deal with a situation where there are multiple scores.
That's correct. And this is what I was trying to get at before, is that I do think in a lot of the solutions that I think might come with concerns that come with looking at injecting adaptive functioning into this space, is I do think states have some discretion about when you want to sort of focus on IQ alone as a threshold matter. And I do think to the extent that a defendant or just can't come in and show that your multiple scores have any realistic possibility of dipping below any concerning range, that is a time where a state can say, we don't want to inject any of this other stuff into it, just focus on IQ.
Okay, so what we are looking for here under our precedents is the evolving standard of decency that exists on this issue about how to decide whether someone who's sentenced to death has significantly sub-average intellectual functioning. In prior cases where we have tried to determine what the national consensus is, we have looked at state laws, things that are enacted by the state legislature, on the theory that they reflect the moral judgment of the people of that state as expressed through their elected representatives. But what do we do with a situation, and let's say that if a state made the law through case law without thinking that it had to do something one way or the other because of our decisions about constitutional standards. Put that aside. What do we do with a situation like we have here, where state courts and lower federal courts are trying to figure out what we said and what Hall and Moore mean? And so their decisions reflect their interpretations, perhaps erroneous interpretations, of those two precedents of this court. Do we look at those to see whether there's a national consensus?
No, I don't think so. I think there's a difference between the idea for a national consensus is when a certain moral judgment has the imprimatur of the people. I don't think that happens when a court imposes that standard on an incorrect understanding of federal law. So to the extent that this court is still doing head counting for purposes of Eighth Amendment, I don't think that courts misunderstanding Hall or Moore would factor in favor for whatever new rule is being proposed.
Now, I don't know whether you've surveyed the state statutes, so perhaps you're not in a position to answer this question. But if one were to survey the statutes of all the states that have the death penalty and see whether they have adopted one approach or another approach to the situation we're dealing with here, what would we find?
So I can't speak to the legislatures just because I don't know what was motivating them. Alabama was able to catalog, I think, a few examples in their brief of instances where state courts were applying what is technically the one low score rule. That erroneous understanding of Hall and Moore, which again, we all agree is an erroneous understanding of Hall and Moore, I don't think that that counts as a moral endorsement to the one low score rule.
Now, Justice Kavanaugh asked your friend about the advantages and disadvantages of the safe harbor as opposed to the alternative. And maybe you would I'd be interested in what you have to say about that. If there's a safe harbor in the sense that a person sentenced to death who's claiming intellectual disability has to meet some concrete standard before the case can go on, will there not be greater consistency and predictability? And is that not one of the lodestars of the court's death penalty jurisprudence, as opposed to a situation where everything is up for grabs in every case, and both sides can bring in experts to testify about the person's intellectual disability or lack of intellectual disability, and every trier of fact is going to decide that on an individualized basis?
So I 100% agree with that, Justice Alito. If I can just emphasize one point, because I don't think there's any practical daylight between what I'm saying and what Alabama was just talking about. I think just the point I was making before is there might not be a per se legal bar on looking at the other evidence, but the IQ evidence may nonetheless be practically dispositive in a given case. So what I'm understanding essentially what my friend was saying is, well, if we look at the IQ scores, it was the defendant or respondent's burden to essentially show at step one that the error range of those scores together reaches 70 or below. Because even if that range never reaches 70 below in the first place, there's no realistic possibility that any of this secondary evidence on the other side of the scale is going to drag you over. So I think that that's more of a practical matter with the facts of this case, where IQ happens to be dispositive.
Well, I mean, like we're at that point though. The IQ, the error range, of those scores leads us there. So we're kind of like, yeah. Dirty Eric, what are you saying here? I don't know who you're talking about. Yes, Clifton Smith did. Yeah, he beat a guy to death. Yeah, he used a hammer and a power saw to beat the guy to death. Basically fucking crushed his skull in. Yeah, and it wasn't just like, walking down the street and somebody scared him and in his tarred fury pushed a guy over into the tracks. No, he beat a guy to death. He intentionally beat a guy to death. There's no question about it. And that's the thing. Nobody's questioning whether or not he did it. That's pretty much been settled. Uncle Bob says do Olympic scoring throughout the high, the low, and then average the rest. I don't think that's going to work here.
Just because there's not going to be anything on the other side of the scale that tips it over.
Thank you.
I'm not sure how that happens. There were 9 scores in whole between 71 and 80. We still sent it back for the court to consider additional evidence, including adaptive functioning, correct? What Justice Alito is saying is states could do something like he suggests, but is that constitutionally required?
I think the difference, though, is...
Answer my question. Would states have to do it that way, or could they do it now in whatever way they thought, one of the 5 ways suggested by the other side, or the way they're actually doing it now?
The answer is uncertain for the reasons I was explaining with Justice Kagan. And I can't, I'm not good enough at math to do this on the fly, but the basic idea is that if those collective scores do not produce a range that even greater...
Has any state adapted that measure? Has any state approached the issue that way with multiple scores?
I don't think so. I think...
Did Dr. King approach it that way below?
In part, I think we focused on IQ and said that it did not fall below 70, and then also said that the other evidence on the other side of the ledger wasn't strong enough to show any other form of disability either.
What I thought he did was exactly what all the experts did, is 3 of the 5 fell within intellectual disability, and then he relied on adaptive functioning to say he thought he was not intellectually disabled.
Let me make one quick point, just addition to this, is that what you won't find in any of the expert reports is a conclusion with respect to what Alabama law asks. None of them found that respondent's true IQ was likely 70 or below. So finding that respondent did not satisfy his
I'm sorry, who didn't find that?
No expert in this case. You won't find any.
Wait a minute, that's what they did say.
No, it's
two of them, at least 2 of respondents' experts found he was intellectually disabled. That was the finding the district court made.
It depends what definition you're using. The experts were using clinical definitions that are distinct from Alabama law.
I don't disagree with you, but the district court was following Alabama law. These things are not statutory. Most of these, the very few, maybe Oklahoma is now, where one score above 76 disqualifies you. I don't know how that's not different than the one score above 70 situation might be, but we'll look at Oklahoma when it comes to us.
Sure.
And that now we're getting into some dicta where she's like, I don't like Oklahoma, so she's kind of tipping her hand there. She shouldn't be. But notice it's what do we have here? How does this work? How does this work? And this becomes a problem. This is an issue when you see these cases about whether somebody's insane or not. This is going to be an example for Nick Reiner. Is he insane or not? Was he insane or not? There's going to be a million experts on that one.
The only one thing I'll add is that I don't think the district court was following Alabama law because, as my friend emphasized, I think a very telling point is that you will not find a single sentence in anything the district court wrote that said respondents' IQ is likely 70 or below. We think that they were laboring.
Oh, is that what you think they did wrong?
I think that where they're trying to get at the start is there's 2 problems. They misunderstood the standard for a possibility idea from the one low score rule.
That was only the 11th Circuit who said that. The district court certainly didn't say that.
But then the basic part 2 is returning to what Alabama law is, which is a numerical inquiry. Does the evidence show that you've been able to drag down the IQ scores below 70? There's no engagement with that. The basic.
But that was never argued by Alabama.
Oh no, it was one of their leading arguments, which was that you did not consider the totality of the evidence. And when you're trying to figure out whether the secondary evidence drags the IQ down,
that's all right. I'll stop. But that's attributing to one broad statement, a specific argument that I don't see. Where did they say that the adaptive functioning should be ignored because the cumulative effect of the score showed he wasn't?
It's 2 sides of the same coin. What it's saying is there's no need to move on to other stuff because here respondent hasn't even carried his initial burden of showing it will do any good.
All right.
Thank you, Justice Kagan. Justice Gorsuch.
A few questions there where I don't think you got to finish your answer. Here's your shot.
I'd be pretending if I remember what any of those questions were. So, I think instead of, turning myself in a circle, if there's anything, that you wish I spoke to.
No, there isn't. I want to get what your argument is. As I'm here to understand it,
right.
not anything else. And I think one of the questions was, what do you think the error was that the district court made and that the 11th Circuit made? I think that was one question that I'd like to hear the answer to.
Right. So I think there's 2 related errors. And the first is what we were saying before, is that they just misunderstood what the substantive standard is. I'm going to look at this evidence. I'm going to ask whether there's a possibility. Alabama looks for a likelihood. So that's mistake number 1. But the second part is even if you say it's applying the right standard, there's still a basic analytical error because if you look at the opinions below, once the courts consider multiple IQ and conclude that it's theoretically possible respondent's IQ dips to 70 or below, IQ falls out of the case entirely. And that's a basic analytical error because, of course, not all possibilities are the same. A defendant with 1 score of 75 is going to have a really different burden than a defendant with 100 scores of 75. So the analysis here, what it should have looked like, is taking count of that dynamic, which is not just saying, well, there's a possibility IQ falls away. I'm going to look at the secondary evidence. You then needed to circle back and see if that secondary evidence was strong enough to drag down the IQ scores below the line set by Alabama law.
And the first error, though, might be itself dispositive, it sounds like.
Yeah, they're independent errors.
Either one of which is sufficient.
Correct.
Okay. And you agree that at the end of the day, before a federal court can grant habeas relief, it has to find a violation of the 8th Amendment here.
Yes. I had one piece to it is that
if you must.
The wrinkle here, which I think is a bit difficult, is the innovation of Atkins, which is to
innovation. That was the word I was looking for.
Which is to identify a federal rule, a general rule against executing the intellectually disabled, but largely outsourcing its definition to state law.
At bottom, though, I agree with that. That's an innovation for sure. But it was trying to give some breathing room to states. Mm-hmm. There has to be a floor, an 8th Amendment floor beneath all that breathing room, right? Yes. Presumably. And before a federal habeas court can grant relief, I would have thought you have to find a violation of federal law.
Yeah, I think that, make of it what you will, but I think the formal way in which it would work is there's a violation of Atkins, federal, because one way or another either met or did not meet, or not even whether or not you satisfied Atkins turns on whether you satisfied state law.
Even if state law is well above the 8th Amendment floor?
Oh, I understand. And I think that the answer would be probably yes, although I think it's difficult.
Really? Is it that difficult?
Well, I think that states have broad discretion to set. I do think that at some point, what I will say, let me take that back just a little bit. That states are free to be more protective than what the Eighth Amendment requires.
How many times have we held that? Right.
100%. So, for instance, what I meant to say is, imagine a state adopted the one low score rule as a matter of state law. Whether or not you violated that wouldn't necessarily implicate the Eighth Amendment because it's more protective than what the Eighth Amendment would require.
Exactly. And so, before federal habeas court could grant relief, you'd still have to go beyond that and find a violation of the Eighth Amendment.
Yes.
Okay. I'm glad we got to that. Okay, and then what do you think about my the holding that I suggested to your friend from Alabama? Looking at what Hall and Moore and trying to figure out, because I agree there's some confusion, and that's why we took the case, the QP we did, was trying to sort some of that out. That under Atkins, states can implement the first prong however they want, as long as they don't treat a single score in the low 70s as decisive, Hall, or use facts extraneous to IQ scores to outweigh a low score more. Is that a correct and fair summary of the law that would provide guidance, do you think?
100%.
On the constitutional floor that you were just exploring, I want to ask the questions to you that I was exploring with Alabama's counsel. If the median is above 70, I understood them to say that the defendant cannot make out a successful Eighth Amendment claim, even if they might have something under state law. Do you agree with that?
I don't think that the Eighth Amendment necessarily speaks to that one way or another. I mean, again,
so you don't agree with that then?
Well, I think that the standard for what the Eighth Amendment is, at least under Atkins, is going to only the Eighth Amendment strictures are only going to reach as far as a nationwide consensus mandates. So when it comes to those specific issues, to the extent there's no nationwide consensus on the question, no, I don't think you run.
So what happens when the median is above 70, or when I assume you're going to have the same answer on the overlap as well. So the overlap approach. Let's say as here 73 to 77, they're saying when that's the case, you cannot make out a successful Eighth Amendment claim, period.
I think that.
Do you agree with them on that?
So I agree that's practically dispositive. On
you said that. I wrote that down, practically dispositive. What does practically as opposed to legally dispositive mean?
Because I think that it's not to say that that there's some per se legal error to moving on to other evidence in light of
the other evidence then, when you move on, if you're saying they can move on or over the state's objection, you're saying the other evidence in some circumstances could outweigh the scores even when the median's above 70. Let me finish. Or when the range is something like 73 to 77. In those circumstances, unlike the state, you're saying the other evidence could outweigh in some cases.
I'm not saying it could outweigh. I think there's a difference between a constitutional rule as to whether or not you need to consider it. But I think in a circumstance where you have consistent scores that are in the high 70s, this is what I mean by practically.
Well, if you're saying that you could consider it, but it's not dispositive, like the state says, then is this just for going through the motions or what?
I think this is a product of, again, this is going to be a product of state experimentation. If you have a totality of the circumstances inquiry in some measure, it doesn't mean all the evidence is equally important. So even if you decide to look at other evidence for one reason or another, the IQ scores might be so strong that there's no realistic possibility that other evidence is going to drag the IQ scores down.
I'll ask it again. If the median's above 70, the state says end there. You're saying no. You can go on to consider the other evidence. The defendant can have you go on to consider the other evidence. In some cases, can the other evidence outweigh the scores even when the median is above 70?
So, yeah, I can imagine a circumstance hypothetically where, suppose you.
That's a yes. That's okay. That's different from the state.
Again, I think that, so imagine.
Which is different because the state of Alabama was saying, no, if you're in the 70s and you're above, like I think he said 73 is your bare minimum. No, you're never going to qualify. And, you heard Justice Sotomayor say, well, yeah, if you're at like in a 76, you're automatically out. You will be executed. The guy here for the federal government saying, yeah, I guess technically it's possible it could happen. So everything's fine over here. So how do you make this equitable? I don't know how you do it. I don't know how you do it. I mean, I think the Atkins standard of having some basic things set up here, I think that's the best way you can do it. David Davis has been a member for 15 months as Sandwich Man. Why would you say all of chat is safe? Because we're all retarded. We're all dumber than 70, so we're safe. John Coleman for $5 says, making his way downtown, walking fast, faces past it. He beat a guy. Boo-doo-doo, boo-boo-doo, boo. Boo-boo-doo, boo-boo-doo, boo. So, yeah, there we go. Bop, 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 bop. Well, that's a hammer. Boom, 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 boom. That's the power saw. Da, 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 da. And I caved your skull in. Yeah, no, I think it's and like I said, guys, that's the thing. Nobody's saying this guy didn't do it. He's not saying he didn't do it. He's just saying he's too retired to be executed.
Circumstance, we have two scores of 71. And then you come in and essentially you have an expert say, well, the content of those IQ exams tested A, B, and C aspects of intellectual functioning. I have all of these, neuropsychological batteries that test other aspects of intellectual functioning, and they're really, really low. I could imagine that being, in a state that has decided to adopt the totality of the circumstances inquiry. That would be a kind of circumstance where, yes, the other evidence could pull you below the line.
So I think it would be constitutional error then for a court to say the median is above is 73. That's the end of it. You can't prevail on an Eighth Amendment claim. That would be constitutional error.
I would be reluctant. So I think that I would be reluctant to phrase this in terms of median, composite, whatever it might be. And this is what I was trying to get at a little bit with Justice Kagan, is that there was some point, in Hall, I think, blesses this practice. There's some point where the possibility of your scores dipping to 70 or below is remote enough that you can rely on IQ exclusively. I don't think this court's precedence paints with a bright line. It certainly doesn't mandate at this point a specific median number, but I think that's the nature of the inquiry.
That's where you differ from the state. The state really was pretty definitive on that, and you're not, which is fine. I'm just trying to explore, because we're going to have to dig through a lot in this case to explore.
Right. But again, this is, returning to the part of, is it a real world matter? I don't think it's going to make any difference here with the idea of.
Here, meaning in this case.
Correct.
Okay, that's all I need. Thank you.
Mr. Graber, I just want to clarify. It seemed to me that what you were telling Justice Kavanaugh might have been different than what you said to Justice Gorsuch, and I want to make sure that I didn't misunderstand that. When Justice Gorsuch read you his proposed rule statement, it didn't include anything about necessarily having to consider the evidence of adaptive functioning, but I understood you to tell Justice Kavanaugh that you would have to go on to consider such evidence, and that in some circumstances it could outweigh the IQ scores, even if they were in, say, the 73 to 78 range. Is there a difference, or am I misunderstanding?
I think a little bit. The part that I would want to focus on is the adaptive functioning piece, is that there's some aspect, I think, as we were getting at, there's some rule of Hall, taking Hall at face value, that at some point IQ scores alone can't be the only thing you're looking at. I do think states have some discretion after that to structure what the other evidence is. And I would imagine that a rule that, for instance, focuses just on conventional evidence of intellectual functioning would be constitutional. The way in which if a state imposed that substantive standard, the question that would follow is, well, are Hall's references to adaptive functioning, that dicta itself, is that something this court wants to give the force of law, that you need to consider this bucket of evidence in particular? I don't see any constitutional mandate to do that. But I think the only point is that so long as your scores touch a certain level, perhaps IQ can't be the only thing you're considering at prong one.
Okay.
Justice Jackson?
I have to say, I think that the arguments and assertions in this case are all over the map and very hard to follow. So I'm trying to understand how and to what extent the district court erred in this case, given the law as it existed at the time the district court ruled, as opposed to the law that Alabama wishes it had enacted, or the cases that it wishes it had already put into place with respect to standards that it's coming up with now. So I understood you to say that there were two errors, something about likelihood or possibility versus possibility. And the second is the one I'm most focused on, which is that under Alabama law, you understand that the law is, and was at the time of the district court, that if you're looking at secondary evidence, was the secondary evidence strong enough to drag down what you had gleaned previously from the IQ scores? Is that what you understood Alabama law to be, and therefore it was an error for the district court not to apply it?
Yeah, and I don't think it's an IQ-specific insight. I think it's just a common sense point about the nature of how preponderance.
I just want to know if it existed as a standard so that we could say the district court erred.
Yeah, I think that when you need to show that a fact is more likely than not in light of the totality of the evidence, you can't then exclude the most probative evidence as part of that weighing. So the issue here that the district court did is it said that the IQ scores allowed it to move on to other evidence, but then it forgot about the first half of the scale. It never looked at the collective weight of the IQ scores all above 50.
But it did entertain expert testimony. And this is the second part of my question to you, is I'm trying to understand, there is a nub of this that's a question of fact, right? Is this person intellectually disabled? And I don't take it that you disagree that experts are going to be involved somehow in making this assessment, right?
Right.
They're not only testing, but they're also looking at other evidence to the extent courts allow them to. So what I understood happened in this case is we had a series of experts come in, evaluate not only the test scores, but also the other evidence, and testify as to whether or not they thought this person had an intellectual disability. Now, I appreciate that the state's experts said no, but the other experts said yes. And the court looked at that and made a decision. I don't understand why that's error from the court's perspective when we ordinarily allow for hearings with evidence and testimony that goes to issues of fact, and the court decides.
Right. So I wouldn't think about this as a battle of the experts cases.
But why not? We had experts who testified to this issue.
That's the part where I disagree with you. No expert testified to whether or not respondent satisfied his burden at prong one as understood by Alabama law. All of the evidence about intellectual functioning was measured against clinical definitions that are different in kind from what Alabama asks. So again, the experts offered in their insights.
Can you point to a case in which Alabama says experts, you can only testify for the purpose of our law to the standard as we are now articulating it? Because to the extent that Alabama sat there and heard the experts testifying and didn't object on the basis that you're saying, or didn't argue to the district court, there's a problem with this testimony because he's testifying to things that Alabama law doesn't consider, I think you may have waived this.
No, I think just the basic point is that it's not an all or nothing inquiry either way.
I'm just trying to understand what was argued below. If you're now saying the problem with the testimony before the district court of the experts is that it wasn't focused in the way that Alabama law requires, where's the objection from Alabama below saying that?
The fact that it doesn't answer the entire legal analysis or legal question before the district court does not mean the expert testimony is not relevant. But the district court then needs to take that evidence, put it into the equation as structured by Alabama law. So what I mean by that is that it is true that the expert said, well, the secondary evidence has a bit of a downward pull, but that is
the expert did say that.
But that is the start, not the end of the analysis. And that's the key problem with the district court, is that it never looked back to see the weight of the thing that it is pulling. Because essentially what it said is this downward pull is dispositive. It never.
This is really kind of starting to get into the weeds here, guys. This is, it's not even with KBJ. This is really starting to, she's trying to understand the story of her life. Yeah. KBJ is really getting confused here. And I think it's pretty straightforward about how you determine what is going on here. Yeah, it says, her IQ been tested? I don't know. I think she's trying. I think she's trying at some point here. Yes, it all comes down to some of the experts you get shot for. Yeah, money is, guys, to mention before, money is helpful. Money is always helpful. Stabby says, I hate this bureaucracy bullshit. Just greed by all these tards. Well, yeah. Johan says, what minimum IQ does a corpo need for Texas to execute one? Well, I mean, remember, 70 is the cutoff. That's where you start to get a developmental disability. So I would assume 70 is right on the line. Although in Texas, like if you have a pulse, they'll execute you. So thank you for the super chat. And Garrett brings up, keep in mind if he'd scored a 69, the very same lawyers would be swearing the score is the only thing that matters. Well, remember, we haven't gotten to Smith's lawyer. This is still the U.S. government arguing on behalf of Alabama did it all right, kill them all. So, and Stabby says, yeah, why don't we just hold everyone to the same standard? Well, we do. We do hold everybody to the same standard. This is the standard. Are you above 70? Yes, then you're fine. You're going to get executed. Are you below 70? Okay, well, now we got a problem. Or are you hovering around? Like, this is the standard. Everyone gets evaluated the same way. So, Connie Desquad for 10 months. Thank you for being here. It says, I think Justice Jackson's IQ is too low. Well, and Connie Desquad also says, if a person is too low IQ to understand the crime, they aren't such to keep around. No, I agree. If that person is too low of an IQ to even figure out what they're doing, they shouldn't be allowed out of the streets. And I think everybody here would agree with that in this, all the people arguing. Fatty Caddy, Nick said K therapy helped him get through issues with his drug use. Do you think those issues were watching your wife hollow like him a call? I don't know. Maybe. Who knows? Who knows? And then Justice Ketanji Brown Jackson, thank you. Thank you, Your Honor, for being here. Says, shut up, white boy. I ain't confused. You just racist. Thank you, Your Honor.
Returned to the collective weight of the IQ scores as part of that analysis.
Thank you.
Thank you, counsel. Mr. Waxman?
Mr. Chief Justice, and may it please the court, just to clarify one thing, the statutory standard in Alabama for prong one is substantially sub-average intellectual functioning.
Now, courts sometimes use the term, and properly so, true IQ of 70 or below. But every court in Alabama and this court and every other court in every other state that I am aware of understands that raw observed.
This is Clifford Smith. This is Joseph Smith's attorney.
Test scores is not the definition of true IQ. Now, in deciding whether a defendant has carried his burden to prove that he suffers from substantially sub-average intellectual functioning, Alabama law, like that of nearly all other states with the qualified, sometimes exception of Oklahoma, requires courts to evaluate all probative evidence as to intellectual functioning offered by either side. That includes evidence of intellectual functioning other than IQ test scores, at least where a court, considering expert testimony, concludes that those scores alone don't decide the issue. The courts below did exactly that by evaluating evidence of Smith's significant impairment on other neuropsychological tests of intelligence. This is pages 88 and 90 to 92 of the petition appendix. His grade school records, which showed that on every measure he was 2 to 4 years below grade average, culminating in a diagnosis of mental retardation in the 7th grade. The warden and the solicitor general asked you to reverse the lower court's faithful application of Alabama law, and I am holding all 12 reported cases on this issue post-Hall in Alabama, and there is not a single case, including the 2 that my friend mentioned, in which the court said, we're only going to look at the test scores, we are not going to consider other evidence. Perkins itself, which is the lead Supreme Court case, I'm sorry.
Thank you.
Before you go on with the another granular argument, what is precisely, to your understanding, is Alabama law?
Alabama law.
Just the pure law, not this case. What does it require?
Alabama law requires that in evaluating whether an individual is intellectually disabled, 3 prongs must be met: substantially sub-average intellectual functioning, substantially sub-average adaptive functioning.
The school records are not IQ tests, but they show you, remember, it's this holistic approach. Remember, we all agree an IQ test isn't the end-all be-all, but it provides a good measuring stick. Okay, well, we all agree he's in the 70s. How stupid is he? And these school testing show, wow, he's dumber than a doornail. He's in the 7th grade, and it sounds like he's as smart as a 3rd grader. So it's very important. Like, these are helpful. They help shape and provide context to what we're looking at is how stupid is he? So.
And onset before the age of 18. And the Alabama Supreme Court in Smith versus State specifically said and subsequently repeated that the Alabama legislature has adopted the most liberal definition of intellectual disability for purposes of the 8th Amendment.
Do you agree that compliance with Alabama law would be compliance with the 8th Amendment?
In this instance, yes. I could imagine a situation in which, Alabama said, we're just never going to execute anybody who gets a score. Let me just put it a different
way. Do you think that the statement, in theory, the pure Alabama law, not an application year, is enough to comply with the 8th Amendment?
In this instance, given the way that Alabama has defined intellectual disability, yes. Okay. In other words,
Joseph Smith is a white guy, so no. He's a white guy. Sorry, swing and a miss. But it's interesting. He has to acknowledge that is Alabama laws done properly? Does it comply with the 8th Amendment? He has to go, yes. Well, technically, yes, it is. And they point out here, and they say, in other words, when they're talking about the AEDPA, this is the Anti-Terrorism and Effective, and this is an actual law, the Anti-Terrorism and Effective Death Penalty Act. That's an actual law, chat. So that's why you see the AEDPA.
To go to Justice Gorsuch's question of both of my friends earlier, of course, a federal court, and here a court is not sitting, this is not a post-conviction, EDPA type review. The trial court never held this hearing and heard this evidence, it is certainly true that a federal court cannot reverse a state sentence unless it violates the Constitution. That is exactly what both lower courts held, and that is got to be the case because, as Atkins explains, federal constitutional law in this area incorporates state law.
Do you think the Eighth Amendment means something different in Alabama? Could mean something different in Alabama than it means in, let's say, Florida or Texas?
No. I mean, I think,
Okay,
I will, may I just add one
Yes,
sentence?
sure.
As we pointed out in our brief in the appendix, and I'm happy to answer questions about any particulars, there is no state, every state that has considered multiple test scores post-Hall, and it may also be true pre-Hall, I don't know, with the limited exception of Oklahoma, and Oklahoma only when there's one score above 76, has said if there are multiple scores whose SEM ranges individually reach 70 or below, you consider other evidence that is relevant to intellectual functioning. That is a consensus.
If the Eighth Amendment has to mean the same thing in every state, then there is the conundrum of Atkins' reference to the discretion that is afforded to the states. And one possible interpretation of that seems to be the one that you are advocating, which is that federal law somehow incorporates state law, so that in determining whether there's an Eighth Amendment violation, the court is to determine whether there was a violation of state law. But isn't another possible interpretation of that the following, that the Eighth Amendment, as understood in Atkins, gives the states discretion, but there is an Eighth Amendment floor, and the Eighth Amendment floor is what cannot be, you can't go below the floor. And the floor is whatever a definition of intellectual disability, procedures for determining intellectual disability that are impermissible. And so long as the state does not go below that floor, a state court does not go below that floor, there's no Eighth Amendment violation.
I'm not sure. It seems to me so long as the state court does not apply the quote means to enforce this constitutional rule, which is the language of Atkins, in a way that is inconsistent with the Atkins principle that persons whom a court interpreting court law that itself is applying the Eighth Amendment standard considers to be satisfying of all three prongs. In other words,
so I take that as an agreement that it would be possible for a state to come up with procedures that would violate the Eighth Amendment, right? I mean, you wouldn't want to rule that possibility out.
Oh, of course. I mean, that was exactly what happened in Hall. And in Moore, for that matter, and in Brumfield. And in every single one of those cases, the court remanded to the state courts, which then heard all of the relevant evidence, not just IQ test scores, all of the relevant evidence, and concluded that the defendant had, in fact, satisfied his burden to show all three prongs.
Mr. Waxman, if a state law goes above what we might say the Eighth Amendment floor is, and a federal habeas court deviates from what state law requires, does it violate the Eighth Amendment?
No, I mean, the example would be, let's say a state said, look, we've read all the other cases, but in our state, we're not going to execute anybody who has a true IQ below 80. And we're going to hear.
Hey, guys, notice this is where we're at now with this. So the federal court has to apply the state law, and if the state law goes well beyond what we require, but the federal court applies it improperly, is that a habeas grounds? Do you see it like habeas stuff is an entire like weird thing on its own. Like, I don't think you got like, it's something I've had to like try to understand. It's so fucking weird. It's so weird how they do all this. You guys like realize my SCOTUS favors men. That's not, you guys are being
all the evidence, but a true IQ below 80, you win under state law. A federal court couldn't
grant habeas in that circumstance.
Right, yeah. Right, unless there was a compelling argument that the true IQ was below 70.
Right. Yeah. But it might be a violation of state law, but it isn't a violation of the federal Constitution.
That's right. But what we have here is a situation in which every state, with the very limited exception of Oklahoma, says IQ test scores are not equivalent to substantially sub-average intellectual functioning because that is a condition, not a test score. They are highly probative, considering the standard error of measurement of what actual IQ is.
So we don't have to really consider Alabama law because what you're articulating is the Eighth Amendment standard as you see it based on what you're pointing to in a consensus of the states. But just to kind of clarify the position on this thing we've been going back and forth with about what is the role of state law, really Alabama law here does not matter to your argument?
Alabama law matters a great deal to my argument because, as this court has taught, we leave it to the states to apply appropriate means for enforcing the Eighth Amendment guarantee. And that is what the Alabama appellate courts have said repeatedly that they are doing in considering both evidence of IQ test scores, if there are any, and where those scores are determined upon expert testimony to be inconclusive, other evidence of intellectual functioning, including, in this case, 4 other psychometric tests that test intellectual functioning, and a history where in the 7th grade he was medically diagnosed as mentally retarded. And considering all those factors, the court found, both the district court and the Court of Appeals made clear on remand, that with respect to evidence of intellectual functioning, including but not limited to test scores, he satisfied prong 1. The Court of Appeals then went on to say, in its opinion on remand for this court, that the additional evidence, I'm quoting from...
No, I mean, like, when you think about it, guys, does that sound like he's mentally, like, does it sound like he met the requirements? I would argue yes. It sounds like he met all the requirements. Doesn't it? At least to me, it does. It's not just his IQ, but there's a lot of things saying this guy is a tard. So...
page 8A of the joint appendix, which is quoting from Hall, the additional evidence of Smith's adaptive deficiencies plausibly supports the district court's reading that although Smith scored above 70 in IQ tests, his actual functioning is comparable to that of individuals with a lower score.
Thank you, Mr. Rucker.
Thank you.
Putting aside how it applies in this case, the SG's methodological approach, as I understood it, I want to make sure whether you agree or disagree with it. What I understood the Solicitor General to say is that the scores, start with the scores, but then you have to go on, usually, maybe always, to consider all the other evidence. But then when you make the final evaluation, you can't forget about the scores as part of the overall analysis.
That is, I agree 100% with that, and the district court did nothing of the sort.
Right. On that latter part, I know you disagree, but on the methodology, anything you disagree with the Solicitor General on?
My memory is even worse.
I'll push it a little further. I mean, it's possible that the place you do disagree is, I think that the Solicitor General had an exception for scores that were, this is his in the brief, many 90 scores. And he said, the scores can be such that you wouldn't have to. I think he had that exception, that caveat.
I agree with that. I mean, you can take an example, for example, of somebody, I'm not sure if I've exactly got his hypo right, but let's say 4 90s and 171.
Right.
The court would certainly hear expert testimony on that. There may very well be expert testimony, maybe even agreement, that the 71 is in fact the result of malingering, or that it is a statistical outlier, and taking into account other evidence relevant to intellectual functioning should be disregarded. But I think a state court that said, come on, the guy has 4 90s and 171, and I've heard expert testimony on both sides, and I find on the basis of that the defendant has not satisfied his burden of proving by a preponderance. What we have here are 4
on that hypothetical.
If I may just finish my sentence.
Yes.
No. Wow.
What we have here are 2 experts who said 4 of the 5 scores are within the range of intellectual disability. The district court itself specifically found that, and so we're not in that hypothetical range. But I agree with the Solicitor General.
On that hypothetical, 3 or 4 sentences later, on that hypothetical, would it be...
I couldn't contain myself. I'm sorry.
I know.
I apologize.
Never. Would it be permissible for a district court to say, well, you got 4 90s and 171, that's enough?
That's enough what?
That's enough to show significantly substandard intellectual functioning. It could do that in that situation.
I mean, the review is for...
I think this is the right answer. Yes, it's always possible. I think you could say, yes, it's highly unlikely, but you can't, never and always are the most dangerous words in law, because there's almost always going to be an exception to whatever you're arguing.
Clear error. And unless there was some compelling testimony to discount the 4 90s, it would be clear.
There's no situation in which IQ scores could in and of themselves be sufficient. So the court could say, look, I've looked at these IQ scores, and that's enough. The statistical possibility that the true IQ is below 70 is so small that the defendant can't possibly prevail.
I mean, I'm not aware.
The court always has to hear additional evidence about adaptive functioning.
I don't think that's the case. And in fact,
I thought you said just the opposite. Is that not right? You said the court in that case would not have to look at adaptive functioning evidence.
Right. I mean, if there's going to be expert testimony, pro and con, with respect to the administration of these tests, and if the court hears the expert testimony and says that on balance, I credit the expert who says that the 71 was a result of malingering, or that the 71 is an outlier, or that the 71 tested, as my friend, the Solicitor General's assistant says, tested certain aspects of intellectual functioning, but not others that are really important, and it should be discounted. A district court that credited that testimony would not err under the Eighth Amendment, so long as it was consistent with state law.
What you say in your brief is that there is a near unanimous consensus of the states that multiple IQ scores must be assessed holistically in light of all relevant evidence.
That's correct.
And so if there are multiple IQ scores, there are 5 100s and 171, the court can't just say the defendant cannot prove that he's intellectually disabled. The court would have to hear additional evidence.
The court would certainly have to hear expert testimony about the reliability of the, what are we up to now, 500s? But a court would certainly be within, assuming state law permitted it, a court would certainly be within its rights to say there is no other evidence of intellectual functioning that could reasonably convince me that this man who doesn't fall remotely within the borderline, even taking the most generous standard error of measurement, and I'm ending my inquiry there. He would have to be able to show evidence on one side or the other that the test scores are in fact were properly administered and reliably interpreted. And there are Alabama cases in which the state has offered extraneous evidence, that is evidence other than test scores that go to intellectual functioning, to say even though he scored within the range of 69, he's not intellectually disabled.
And so I think your arguments or your responses to Justice Alito are all really heavily focused on the fact that what the court is actually doing is hearing evidence, that the court is actually assessing, making this determination about intellectual functioning in light of expert testimony about these things. And so it seems kind of odd to have rules that would be rigid with respect to how these particular experts are testifying or what the impact of the various scores are in this environment, I think. I mean, am I right about, part of the confusion that I'm having is that Alabama and the SG seem to want to remove the evidentiary aspect of this and make it into just a question of law, as though the court, without evidence, is just making this decision. When in fact, the court is hearing from experts who have looked at the test scores and all of the evidence and are testifying as to their beliefs regarding this particular legal criteria. And then the court is deciding.
Let me make 2 points in response to that, Justice Jackson. First of all, it's too late and irrelevant for me to pick sides in Moore versus Texas, but what the district court did in this case is precisely what the Chief Justice in dissent said was properly done in Texas. A court hears the evidence, all probative, relevant, and admissible evidence on both sides, and makes a determination against the standard, the Eighth Amendment standard, with whatever procedural or substantive applications that state law provides. And in this particular case, what I understand the state to be saying is, look, as a matter of Alabama law, whether you're talking about, I don't know, the overlap or the average or the median or whatever, if you don't have an actual score at 70, you don't get to, it is error, clear error for the court to hear other evidence that is probative of intellectual functioning, including other psychometric tests that test intelligence as well as adaptive functioning, and the fact that the guy was diagnosed as mentally retarded in the 7th grade. Of course, a court should be able to determine that. There's just no warrant for this court to announce a constitutional rule binding on all states that precludes consideration of evidence that Alabama and the other states and the medical community properly considers probative of intellectual functioning.
I think that would be setting up.
And that's kind of their biggest thing. We should be allowed to use all this information. The 11th, not only did the district court say there's something wrong with this guy, the 11th Circuit said we read through all this stuff And we found even more arguments. And the state of Alabama is like, whoa, no. He's above 70. We should be allowed to execute him. Notice that is where we're at with this. This is the issue here about what's being argued. And this is really where it comes down to. This is the heart of the argument. And this is his argument here. There's nothing precluding, there's no warrant for this court to announce a rule binding on everybody that precludes the consideration of evidence that Alabama and the other states would consider probative of intellectual functioning. El Augusto says, what did he do? He beat a guy to death and tried to rob him. He got convicted. It was a murder. It was a robbery. He beat a guy to death. So, and hold on here. Where is Dashin saying, good question. Does this poly take into account my cognitive ability at the time I committed the crime or at the time I'm tried? It's a bit of everything, because notice we're going into what you were throughout your life. Now, let's say you were fine the whole time, but, when you're 25, you got kicked in the head by a donkey at the county fair, and from now on, you're like, nah, and you don't understand. Okay, that would change things. But no, it's throughout your entire life. Because theoretically, if you got better, they could argue, well, you've gotten better since the crime occurred. But no, this guy has been mentally retarded his whole life. So this is like an entire survey of his life. They go through his school records, his 7th grade records, since he's been in prison, his IQ testing. They really did a lot here. And guys, the thing is, if you're really, really smart, and I think somebody mentioned this before too, but it's true. The only people who are guaranteed ever be tested for things are the people who are super smart and the people who are super retarded. So we got to figure out where they are. But Trevor, that's a good question. But it's the totality of all of it. Because in reality, remember when Alabama was deciding whether or not to kill this guy, the death penalty phase, they had to consider everything. And now he's arguing they didn't do a good job. And yes, the federal district court said, you're right, Alabama didn't do it right. They didn't do a holistic approach. They didn't look at this properly. And the 11th Circuit said, yeah, we actually agree. And not only is the district court right, but we found even more stuff that they didn't do right. So that is where we are. That is where we are. Hope that answers your question. You got mail. Nice. Your mail comes in at like 9 o'clock at night. Dang. So, he planned out a robbery. I don't think he planned it, but another guy did. Him and another guy did it. Yeah, he did rob him. $150 as work boots. Yeah. Marlene says, why weren't these issues tested in all the appeals Smith had in response? They were, but federal habeas petitions are a separate venue that you challenge stuff. Federal habeas petitions allow you to challenge stuff under the United States Constitution. So I don't know exactly, but what was raised on his appeals. But think of it as like a entirely new track for your appeals, because it's an entirely different set of courts. And this is long-standing federal habeas work. The Supreme Court, like that's something that's been around for decades now. So this is a very standard situation. This is normal. I hope that answers your question, Marlene. Very good question, though. AC360 No Scope says he scored 74, 75, 72, 74, 74, 75, 78. None of those are retarded, not one. The margin of error for the 72 is 3 points. That gets you under 69, possibly. So, yes, one of those counts. Even the court's acknowledging one of these counts. Shredder S 07 says affirmative action, Ketanji Brown Jackson. Yes. Luke says, wait, if I get a lobotomy in my 20s, I'm not considered retarded? Well, not necessarily. County Death Squad says, all I'm hearing is the necessity to bring back eugenics. I mean, yeah, I'm sure this guy led a pretty fucking nasty, like, poor life. I'm sure the quality of this guy's life sucked in general at this point. And then Debbie O for $5. Hi, Debbie. Is saying, I remember the IQ test in elementary school, maybe grade 3. Why did they not determine he was retarded until the 7th grade? That seems sus all on its own. No, I'm sure that they realized he was retarded and that they dealt with it, but they finally had an official thing and they're like, we can't do anything more for him. Maybe that's as far back as his records go, too. I don't know. I mean, there's a million different reasons why that's there, but that's what they have. And I don't doubt this guy's dumber than a doornail. I think if we talked to him, we would probably think that, too. So, but they're very good questions. Very good points, you guys. Thank you. Fun Gutsy says the standard deviation for IQ data is 15 points. Yes. And Nero says, even as a 3rd grader, I knew not to rape or murder. Sure. And I don't disagree with you, but I'm saying as of right now, the court said you're not allowed to execute retarded people. So the court has set the standard. We have to operate within the rule parameters.
Floor for all states, not binding the states. The states could always go above the floor. But in any event, I understood Alabama and the Solicitor General have different views on that, and that Alabama has that view that you just said, that if the scores, the median or the overlap is above 70, then that's it. You can't make out a successful 8th Amendment claim. I understood the Solicitor General to say, no, you still go on and consider the other evidence, but don't forget about the scores. I gather methodologically, you agree with the Solicitor General. You think Alabama's wrong on that.
Well, I think
it's not really a question, but you can say yes or no to that.
yes, because number one, there is no Alabama case that, and there was no evidence in this case with respect to whatsoever applying some aggregate score as the test for true IQ. Absolutely not.
But then
median, I'm sorry.
You can have one sentence.
I will reserve my one sentence to answer your question. I apologize.
Mr. Graver doesn't get a chance to stand up and tell me whether I'm wrong about my summary of his, but then I think he would say, okay, you agree on that, but he says that the court here made 2 fundamental errors. One is it treated the preponderance standard as a possibility standard, and the second is it thought that it was not permissible for it to get back around to the scores. And he says that those were the 2 errors. Were they?
Okay, so real quick, AC 360, the composite of the score is 76. I don't disagree. That's the composite. You can't just say, oh, well, one was low. The courts here did that, though. Like, you can't, like, don't fucking jiggle your dick at me. The district court said that. The court of the 11th Circuit said that. They are like, yeah, the one of these is below 70, possibly. What does that mean? We think that coupled with everything, he was too retarded. I'm just telling you how it is. You can sit there and read, scree, and piss and shit all you want. I'm just telling you what it is, man. You're mad at me because I'm telling you the score of the game. Linebacker sacked the quarterback. Go get mad at somebody else. I'm just telling you the score. I'm telling you the play-by-play here. I have a degree in mathematics. Okay, great, but the 72, if the margin of error is 3 points, is 69. And it's not clear under the law how you weigh all this. Do you do it as a composite? Do you say, well, yeah, technically one could have been under 70. Does that count? Does that trip the thing off? Like, part of this is we don't know what, like, the rule is on this. So I'm just saying, like, you know, it's like you're getting mad at John Madden for saying, you know, Ronnie Lott sacked a quarterback. Like, I don't know. I was like, go get mad at fucking Ronnie Lott, not John Madden. Stacy says, doesn't the average American read at an 8th grade level? Yes. And the military trains people at an 8th grade level in basic training. Like, yes, there's some basics like that. Cool channel name says, can people with an IQ below 70 vote? There would be a very, and I think this is true, the idea is you probably couldn't figure out what to do to go vote. So, for example, a person with a 70 IQ would not be able to think and formulate, I have to go to a polling place. I have to go to the right one. Would that person be able to read at a level well enough to comprehend a ballot? Would they be able to talk in a way that makes sense that they could actually get a ballot? And then from there, could they actually follow directions? Probably not. Probably not. And could somebody below 70 get a pilot's license? No way in fucking hell. No one's getting a certificate. I mean, all the requirements for a pilot's, like, no. Like, you would have to, like, there's no way somebody would have that ability and have those skills necessary to do that. So, there's no way. And then Connie Desquad says, how sad is DSP going to be when one of his dents gets sent to the electric chair? Oh, no. Goodbye, Iron Chef Sakai. He gets the electric chair. Only iced coffee gets the needle. Oh, no. Oh, no. Phil's going to have to go save him. And then EDW Raptor for 10 subs. And get us on our woo here. That's right, chat. You know, thank you for your support, your generosity, EDW. How about a pirate's license? Okay, well, yeah, probably. I defended the conclusion at every turn. I mean, there's like, I mean, it makes sense. I'm not like, if you want to disagree with it, you can. But yes, I think it makes sense. This guy is on the borderline. He's apparently mentally retarded. Multiple people have assessed him. The guy dropped out. The guy left school in the 7th grade and was like as smart as a 3rd grader. Yeah, I think he's pretty fucking retarded. I bet you I could get him to commit any number of crimes and he would go along with it. He's like a fucking 8-year-old. So. Well, yes, you technically could vote dead and in a coma. Okay, fair enough. I mean, har. Debbie's saying that's the whole point of this case. Yes, it is. He could also be trying to get a lower score so as to try and be spared the death penalty on advice of his lawyer or family member. Yeah, but I mean, he got within 72, 74, 75, and 70. Like, he got within that range of like 3 points. I don't think even if you're that, like, you'd have to be super smart to have like that 4-point window to intentionally do that. I'm betting that's his general IQ is like a 73 or a 74. But the court looked at it and said, look, he may be a 74 like on the test, but the test alone isn't the make or break. It's when you added everything else plus the test, you're like, this guy really is retarded. He really is. He's completely lost. And that's why they're doing it. That's why they're doing it. Can a 70 IQ could hold a tar job? I mean, maybe, but those are jobs where it's like make work jobs where they're not really doing anything. So, yeah, you can hold that job, but it's not the same as a normal job. Let's see here. Oh, Winter Soldier says, I have a degree in education in the 90s, and it was the 5th grade when I wrote training materials for 5th grade reading levels. That makes sense. You know, yeah, it's a very basic reading level. At what IQ do you see the tard strength? I don't know. Yes, they could theoretically be a Walmart greeter, but even then, somebody's going to have to watch them and really keep on top of them. You know, you'd have to make sure that they're paying attention and, like, you know, minding, like, you couldn't just let them wander off on their own. Could they collect baskets? Probably, but even then, remember, somebody's going to have to really keep an eye on them. So, Bronca had a lot of base takes on mentioning IQ and HBD on his last 2 streams. Yeah, I mean, like, the IQ doesn't lie. I mean, the IQ curves are true. The bell curve is undefeated. IQ and race, IQ and all of that. There are distributions for all of that. And to argue they don't exist is laughable. Stace says, I've seen plenty of Down syndrome people collecting baskets. Yeah, but I'm betting those people with Down syndrome have a significantly higher IQ than 72. Remember, 83 is the bearer of training for the military, but also somebody who's at an 80 versus somebody who's at a 72, they're going to be light years apart in what you could teach them and what they can do. So yes, welcome to Costco. I love you. Oh.
No, I think that the district court's opinion refutes both of those contentions. The district court plainly and expressly found by a preponderance of the evidence that he satisfied prongs 1, 2, and 3 independently. I don't even remember what the second part is, but that would be...
The second part is important because Mr. Graver says that the court thought that it couldn't get back around and say, look, there are 5 scores here. Most of them don't reach the 70 threshold, that sort of thing.
I mean, the district court opinion will speak for itself. The court said that he showed, the court's opinion discusses each test score. It discusses each of the 4 experts' testimony. It discusses what the experts showed about the other psychometric intelligence tests, about his history, and what each expert said about that, and then concluded applying Alabama's standard of substantially sub-average intellectual functioning, that he, by a preponderance, he had met that standard.
When you talk about that standard as Alabama's, that's straight out of Atkins, isn't it?
It's straight out of the Alabama statute.
Also straight out of Atkins, isn't it? And Hall and Moore.
Atkins.
You say it's at the same standard everybody except for Oklahoma uses it. So
Oklahoma
they all use it for a reason because it came out of our decisions, right?
Well, the reason it came out of Atkins was Atkins found that there was unanimity among the expert practitioners and associations.
Oh, but fine. Whether the chicken or the egg came first, it's in Atkins.
We're in violent agreement.
All right, thank you.
Counsel, Mr. Waxman, I don't do this often, but Justice Gorsuch set out a statement that he asked the other side whether it was a holding that they disagreed with. You read something.
I did.
Yes, you did.
You want me to read it again?
Please, because I'd like Mr. Waxman.
I don't remember it, so I
No, and I took it down and I can't find my notes now. So could you please, if you do that.
I would be delighted.
Thank you.
The question is just how to understand, which I've struggled with, both Moore and Hall. And I read Hall as saying that you cannot treat a single score in the low 70s as decisive. And I read Moore as saying you can't use facts extraneous to IQ to outweigh a low score. Fair?
Fair with the caveat that extraneous to IQ. Well, no.
I mean, that's what the court did.
If what you mean is extraneous to the question of what his true intellectual functioning is,
No.
yes.
Yeah, it started looking at things to try to outweigh a low score. It started grabbing at other facts.
Well, it not only, I think it would be a due process violation for a court to say the evidence on the test scores is inconclusive, but I'm not going to let either the state or the defense put on evidence. I mean, this court has Washington versus Texas and Crane versus Kentucky and any number of other cases basically stands for the proposition that you can't artificially limit presentation of evidence that is relevant, probative, and admissible.
In Moore, counsel, the 2 scores were 74 and 78. And we held the state court violated Hall when it discounted the lower end of the SEM because he was, quote, malingering. There we held that when there's an IQ below 70 with the SEM that adjusted for the test standard error, then you must permit evidence of whether clinically he falls within the range of intellectual functioning details. Correct?
That is a correct holding, and my understanding of the disagreement between the majority and the dissent was leaving aside the Briseno factors, whether a district judge committed clear error in determining the issue the way it did.
And so Justice Gorsuch's second reading is wrong. We do require clinical evidence, but the finder of fact could rightly not be persuaded by it, or it could be persuaded by it. That's your point, isn't it?
That's correct, unless the court concludes that I've got, let's make it now 10 IQ test scores, all of which both experts agree were properly administered and reliable. And in light of that finding, 1 test score of 70, there is no evidence other than the testimony of the experts that could change my mind that he has not met prong 1.
But that's not the case here.
I mean, we're not in the same time zone is that?
No, because we have 3 tests, all of them.
4.
All of them within the SEM, he could be 70 or below.
He could, and he in fact demonstrated by a preponderance that he is.
And in fact, Dr. King, whom they rely upon, the petitioners testified.
Not that Dr. King, chat. But yes, remember, it's also preponderance standard, 51%.
That the scores were within intellectual disability, but then he went to other factors to say why he thought he was functioning within.
Well, I think Dr. King's testimony will stand for itself. The district court found his testimony to be less credible than the other experts. What he said is, we have 5 scores and they're all above 70. 4 of them, looking at the individual standard error of measurement, are within the range. But he was asked a question by the prosecutor, are you aware of a theory by Dr. Flynn that when there are multiple test scores that are close together, the standard error of measurement will be reduced? And he said, yes, I'm aware of that. There was no testimony about what, in this case, that standard error of measurement would be. And it is inconsistent, flatly inconsistent, with what this court said in Hall and what, in at least 5 cases, Alabama courts have done, which is always apply plus or minus 5.
And in fact, they've rejected Flynn, correct?
I'm sorry?
The district court rejected the Flynn effect in this case.
Yes, we're not relying on the Flynn effect.
Thank you, counsel.
Thank you.
Justice Thomas? Justice Alito?
It would help me to get clarification of your position on a couple of issues. I took from your brief and from your answers at an earlier point in the argument that whenever there are multiple IQ scores, they must be assessed holistically in light of all relevant evidence. And by relevant evidence, the relevant evidence would include evidence about adaptive functions. That's how I understood your brief. That's what I understood you to say at an earlier point in the argument. But then you just recently said, if there is a case where there are, let's say, 5 100s and 1 71, the inquiry could be cut off at the point. It would not have to get into any adaptive function. The inquiry could be cut off at that point. Is that correct?
I think, considering the expert testimony, if a court...
Expert testimony about the IQs or about other things.
About the IQ test administration and meaning of the test, a court could say, look, nothing you can offer is going to convince me that in fact his true IQ is 70 or below. That would be measured, that determination would be measured for clear error. In other words, what the court would be saying is, yes, of course, each side is entitled to offer.
Okay, so there could not be a categorical rule. There can never be a categorical rule that IQs plus testimony about the IQs is sufficient. And a court would err if it went beyond that and opened up the possibility of holding that there was not intellectual disability. You said it would, the court could do it. And what would be reviewed for clear error.
What I am saying is, if there are multiple, 1 or more IQ test scores that are within the range of intellectual disability, that is 70 or below, it is error for a court to refuse to consider expert testimony and evidence relating to other psychometric tests and school and prior diagnoses to determine whether the defendant meets his burden to show prong 1.
So in just about every case then, IQs and testimony about IQs can never be sufficient.
I don't know how to, I've given you every possible answer that I have. I think a court looking at 500s and 171, considering the testimony about how those tests were administered and what the reliable results of those tests are, could conclude, look, that's it for me. There's nothing you could show me that would change my mind.
I'm still perplexed also about your view regarding the relevance of Alabama law here. Does it matter what Alabama law says on these points, or are we looking for the minimum 8th Amendment standard?
What Alabama law says about how this is or isn't proven is the 8th Amendment commandment of this court in Atkins. That is, it allows states to apply various standards in order to make a determination about the 8th Amendment violation or not. As we know, the state can apply different levels of burdens consistent with the Due Process Clause. There are some states that say, if somebody is charged with a crime and comes in with a score of 65 even before the trial, he is presumptively ineligible. I mean, there are lots of ways in which states have established rules to enforce quote, the constitutional mandate we announce.
One final question. How are we to determine what the national consensus is based on state court decisions that have struggled, that are struggling to understand what this court has said in Hall and Moore?
The state has cited one and only one case in which the court has expressed perplexity, and that is not even a state court. It is a federal district court applying the federal death penalty in the Eastern District of New York. You can look at every single.
Let me just ask it another way, and then I'll give up.
Well,
how are we to determine? The state courts are trying to apply our decisions, and would you deny the fact that that's what they're doing? They're just going off and deciding what they think is the morally appropriate way of dealing with this question, or are they trying to understand what this court has said? And if they're trying to understand what this court has said, how can that show a national consensus in the sense in which we've used that term in prior death penalty cases?
The state courts have uniformly looked to Hall versus Florida and this court's announcement of its rule in Hall, its two-part holding in Hall versus Florida, and said to determine substantially sub-average intellectual functioning, we look at all probative evidence, including, of course, the test results from properly administered IQ tests.
All right, thank you. Thank you.
Justice Sotomayor? Justice Kagan? Justice Gorsuch? Justice Jackson?
Can I just quickly point out that in response to Justice Alito, he asked about whether or not there could ever be a categorical rule that scores alone are enough, are or are not. And I guess I'm just worried about the clinicians and the people who try to evaluate this condition. And they seem to be saying, I'm talking about the amicus briefs here of the American Association on Intellectual Disabilities, that there are, quote, too many variables to consider in determining the validity of each test score and the convergence of that score with other scores and qualitative information to rationally support the use of only one procedure. They seem to be saying that you've got to look at a lot of different things in order to come to the truth of whether or not this person is actually intellectually disabled. It's not enough just as a clinical matter, as a sort of outside of the context of the case. If we're really trying to get to the bottom of this, you have to look at a lot of things. And I thought that was the thrust of the court's conclusion, that you don't cut people off just because they have a particular test score, that you allow experts to evaluate everything and the court to weigh everything in making this assessment.
That is, in fact, what all clinicians believe. But, of course, there are clinicians who would testify, who would, and in fact have testified in Alabama cases, that there was one case, I'm forgetting the name of it, where the test score was 69. There was only one test, it was 69. And the defense's expert witness testified that she did not believe that, taking into account all of the evidence, he was, in fact, intellectual.
Sure, that's the point of an expert. They look at the test scores, they look at all the information, and they make this determination. So sometimes it's not helpful to have categorical rules that impinge on that assessment.
I think I think we have to be mindful, as this court, members of this court have frequently reminded us, that clinicians determine evaluate clinical evidence, and courts apply the law. In this case, we have a law announced in Atkins that someone with this condition may not constitutionally be subject to capital punishment. There is no court that I'm aware of that has simply said there is no there is a other than Oklahoma, there is a categorical rule. When and if, a court in Alabama or elsewhere is presented with an argument that there should be a categorical rule, or that state law incorporates and the Eighth Amendment permits a categorical rule, that will be for the lower federal courts and perhaps this court to evaluate.
Thank you.
Thank you, counsel. Rebuttal, Mr. Overy?
I had a lot of questions about Alabama law. There's no statute in Alabama. It's ex parte Perkins, and it sets the line at 70. The 11th Circuit understood that at page.
So there we go, guys. That was Joseph Smith's attorney. Now we're back to Robert Overy. He is for the state of Alabama. He's out of their attorney general's office. And he says there's no statute. He's putting out it, and this is common for things in some states, like in Ohio, for example. Self-defense is not statutory; it's case law. So there's no statute in Alabama for this. It's ex parte Perkins, and it says it sets the line at 70. So there you go. This guy, now he's getting a hair. So you guys are talking about showing receipts. Oh my God. Oh my gosh. You guys are being like. Anyways, that's important to look at here.
35 when it said Smith's claim turns on whether his IQ is 70 or below. Smith's counsel has essentially abandoned that misreading of Alabama law from their briefs because he agreed with Justice Gorsuch that the question is there an Eighth Amendment violation? The United States, at the bottom of page 19 of their brief, said that states can require defendants to prove his IQ scores betray deficient intellectual functioning. We agree with that. The Eighth Amendment doesn't preclude an IQ burden, and 20 states, as amicus, agree with us here. Smith's counsel in the 11th Circuit said that 4 and 5 scores are in the range. Both experts, this is JA 83 and JA 221, used the Flynn effect and then subtracted points for the error range. Both of those are not Alabama law, and they didn't consider the cumulative effect, so the court should reverse. The court should remember that this is not just about state sovereignty, but also preserving the essential function of the jury to make a reasoned moral judgment about the criminal and his crime. The jury here had the very best evidence of his intelligence, his 72, the best evidence in his favor, and what's happened decades since then has only confirmed what the jury knew then, that he is not intellectually disabled. The federal courts now have made the demeaning judgment that those 12 everyday Americans rendered a sentence that was so barbarous as to be beyond the limits of civilized society. No, the court should reverse and give the lower courts no more chances, instruct that the writ of habeas corpus be denied.
Thank you, counsel. The case is submitted.
Well, there we go, chat. Notice that guy was like speed running it all in there. Yeah, and I hope this wasn't as flashy and dassy as like an Article 2 case, but it's like, how do we decide how to execute a retarded guy? What are the standards? And this guy came back to some good points at the end. A jury heard all of this in the mitigation phase, in the penalty phase, that he's too retarded. He's just, he's like, I'm a big old tard. Please don't kill me. And the jury's like, yeah, good enough. Yeah, don't care. We're going to execute you anyway. So, yeah. So that is kind of where we are with stuff. I thought it was interesting here to do this. Luke says, nice recommended Super Kino. Well, I don't know if it's Super Kino, but it is pretty good. That's a thing here. That I get, so I appreciate that, but unless you're talking about something else, so you guys are asking some questions here. State's saying, is Ron Jeremy retarded? No, Ron Jeremy was declared incompetent to stand trial. Ron Jeremy has really bad dementia. As of the last time he was in court, like 2 or 3 years ago, he's bedridden. He basically has 24-hour care. It sounds like he doesn't even talk, really. Like his brain is fucking fried. And yeah, for Ron Jeremy, it's probably the syphilis. Anna Wall says, it sounds like the court wants to make it their choice as opposed to the jury. Well, they're just making sure what is the standard criteria here, and was that criteria followed? And yes, this is one of those times where the criteria is not set in stone, but you kind of don't want it to be set in stone, I don't think. I would argue probably otherwise. But Ron Jeremy has not been in prison. He's currently like in a private care facility, but he it's not like he's up and walking around. He's probably, whatever's left of his cognitive abilities is probably in hell. So just telling you, it's probably not the best. So don't get too worried about that. Don't get too worried about, it's not like he's living the high life. Let's see here. What are some other comments? Garrett says, there's a Downs girl working in my local supermarket. She won't let you leave unless you arm wrestle after she packs your bags. Well, does she kick everyone's ass? I'm curious. And then Yorick, yes. How you doing, man? Yes. 83, your forced deportation due to not being able to satisfy drafting requirements. Where do we send everybody? Where do we send all our tards then? Katie, yes, it's hilarious. We have a chat full of retards talking about IQ. Well, it do be like that. It do be like that, Mr. Martin. It do be like that. Stacy says some Down syndrome people have an IQ 10 to 30 points higher, but the average is 50 to 69. Really? I mean, I know there's some that aren't very high functioning, but for the most part, I would assume the average Down syndrome was like 70 something, and then quite a few of them are above that. So yeah, I'm surprised. I'm surprised. I did not know that, but thank you for pointing that out. Samurai Actual says Down syndrome people give you the uncanny valley. Well, I mean, it was a survival instinct for us. Let's see here. So I hope I answered the Ron Jeremy questions for you guys. Cedar Rose saying, when I got tested as a kid, I was deemed average IQ and noted highly analytical. Oh, okay. Oh, awesome. But no, they never tested. Well, I don't know about my brother and sister, but I asked my dad at one point, did they ever test? Did we ever get tested? He's like, no. He's like, you guys weren't drooling idiots, and also you guys weren't building rocket ships in the backyard. So there wasn't, nobody went. He's like, we didn't bother testing me. He's like, in the school never tested you. I'm like, okay. He's like, I knew you weren't retarded. So he's like, you weren't going to run into traffic. And I'm like, he's like, that's kind of what I was worried about. And I'm like, fair enough. Fair enough. So no, I've never been tested. And like I said, I'm probably like smarter than the average bear, probably like a 105 or something. Because isn't like 100 right on the nose. So like, I'll give myself 5 points. Give myself 5 points. Brad says, showing receipt is an IQ test. No, well, I don't know about that. I don't know about that. Yeah, Ron Jeremy's pretty disgusting. Canadian Kate says, Sean, can you do something for Zechariah Anderson? Even in honor of Jeff, someone needs a restream a trial. I'll talk to Hell and see what they're doing coming up here. And yeah, I mean, it's and 2.0 kind of brought that up too. Jeff's passing. The anniversary of it happened a little while ago. Yeah, still sucks he's gone. Especially all the maritime stuff he could be doing. Like, God, he'd be living it up with all the crazy stuff going on right now. And yeah, and it's once again, it's that's all I can really say about that. I'm just gonna leave that there. I don't really know. I'm just gonna leave that there. I don't know. I know everybody misses Jeff. I do too. I prefer to miss him privately. I know some people like to do it publicly, but I don't. But yeah, Jeff, still miss you, man. Still miss you. Hope you're doing all. Not even hope, but I know you're doing okay, and I hope he takes solace in the fact that Connor's doing really well. He's always on. He's hanging in there. Looks like the doggos are doing really well. I mean, so hope he, know he's up there and he's, happy with the outcomes. So, but yeah, I'll talk to Hell about some of that stuff. Okay, thank you, by the way. Anime Exceptional is saying, isn't syphilis curable? Yes, but if you don't get it cured, it basically your brain gets lesions all over it, and it fucking makes you go insane. It's what happened to Al Capone. He died of syphilis. So yeah, it's curable and it's treatable, but you have to treat it. And if you don't treat it, you fucking go crazy. So yeah, it can be treated. Also, remember, Ron Jeremy was born in 1953, so they were just on top of stuff back then, and I doubt he got it taken care of for the most part. Let's see here. Stacey saying, no, that's just the ones you see in public. Well, that makes sense, but I hadn't really thought about that otherwise. And generally speaking, people with Down syndrome are pretty, very nice to talk to and all that. They tested me to see if I float. Well, yeah, that's pretty fucking easy. Believe it or not, I wasn't always a fat kid, though. So, Marlene says, I've never wanted to take an IQ test. I figured I'd be disappointed. Well, nowadays, yeah, I'm kind of curious. Like, I don't think I've tried a couple of those, like, goofy ones online, and they're like, how do you trust those? Because sometimes they're like, you're super smart. Then they say sometimes like, you're really dumb. It's like, I don't know what I am. Like I said, probably somewhere in the middle. I wasn't gifted. No, I was not. I was not gifted. Nope. I was not in the gifted classes. I don't, if I never made that clear, no, I was never one of those kids. I got invited to go do like an independent study thing where you got to go do like extra stuff and presentations, where I mentioned I did like the U-boat thing, and like my mom helped put together, like she got me a black blazer from Goodwill and put some piping on it and got me a hat, and I looked like a U-boat captain and shit. As part of my presentation that we did in like this big convention hall along with other kids. Like that happened. But no, I was not a fucking I was not a gifted kid. So no, I was not in those fucking classes. Not by a long shot. The kids in those were really fucking smart. The kids were really fucking smart. You've been cooking and listening. Oh, well, there you go, Erica. Yeah, pour one out for Jeff. Mm-hmm. Carrie says, I was tested in 3rd grade. I don't remember my score, but I do remember I only missed 3 questions across the entirety of the test. So presumably pretty high. Then. Let's see. Yeah, the thing with a lot of people talking about IQ tests now are the ones you pay $20 for, or they're clinical because something is wrong with them. Well, yeah, I don't know, but I'm assuming the ones they took as kids or things out there, yeah. Or people are like Rockhound and fucking Armageddon. It's like, I won the Westinghouse Prize when I was 9. Crowdy Cat Mom says, yep. Love out there for Jeff. Mm-hmm. Yep. Fungus, he says, very few people actually get real proctored IQ tests unless they have something wrong with them. Yeah, that's what I mean. Like, unless you're super smart or super retarded. But here's the thing. If you're super smart, things are kind of falling apart because generally speaking, if you're super, super smart, you're not super talk. Like, remember, like being on either end of the bell curve the prisons are similar, just in different locations. You have poor social skills. You don't interact. You do really shitty at school. It's hard. Like you're not able to concentrate, get work done. You're combative. There's all kinds of things. It's like, like the retardation is on both ends. At the end of the day. And yeah, something's going wrong and they don't know what's going on. Or if they know you're just super smart, they want to figure out like, how fast can you actually run? But if you're, it just goes both ways. It goes both ways, guys. Let's see here. Wouldn't legions of brains make you smarter? Lasting Tale. Lesions. Hold on. Hold on here. Let's see if we can show this. Let's see. We can show some neurosyphilis, like some lesions on the brain. So here is neurosyphilis, chat. This is what neurosyphilis looks like on your brain. This shit is not good. That's your brain on syphilis. That's neurosyphilis when it gets like That's not a normal, healthy looking brain. So, and Stacey says Al Capone's kid is deaf because his mom had syphilis. Really, I didn't know that. Syphilis can only be treated with more sex. Oh no, no! I don't think that's correct. I don't think that's accurate medical advice. Chat, do not accept that. Marlene says, my sons were in the gifted and my granddaughter as well. Now my feed is full of gifteds are a CIA psyop. Everything's a CIA psyop at the end of the day. Everything's a psyop. Everything's a psyop. The CIA's got its hands in everything, or it's a Mossad op. Yeah, your mom said they didn't want you to become a weirdo. That's what she said. I mean, kind of sounds like my dad. He's like, yeah, you guys were like, you guys aren't like, he's like, there was no need to. Like I said, we're not special. Elder says, you don't think Ron Jeremy has normal dementia? He probably has he probably has dementia, but I'm sure syphilis cooking his brain didn't help things too. They said you were a genius once. Well, there you go. Well, hey, take advantage of it. Elder Gustus said, I remember talking to a dude claiming he was 180. The odds of somebody being somebody 180 IQ would be like 1 in 20 million people. It's gonna be, yeah, you know, you're probably also like Lucy, that one movie where you can like fucking probably make people explode with your mind, but that person wouldn't be able to talk to you. It'd be almost impossible to talk to somebody with that kind of an IQ. That'd be really, 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 really tough. Like that would be a very difficult, like them talking to you would be like you talking to a 2-year-old. It would be very difficult for them to talk to you or want to talk to you. You declare me to be 105. Yeah, I probably was. J-Rock says, I was in fats. Like I said, I wasn't fat as a little kid. Believe it or not. I was not. Das Boot says, you watched Das Boot for preparation. I did. It was a cool movie when I watched it as a kid. Had to watch it on tape though when it was two VHS tapes. And my mom had to look all over to find it. Because this is like 1998 or 97. So it was really fucking hard to find. Before Amazon really got big. Adam Nash says, how does anybody buy a mattress anymore? All the YouTube review channels are bought and paid for. Yeah. But I mean, like, there's good ones out there. Like, I think it's called Big Fig or something like that. It's very nice. But yeah, a lot of them are pretty good. Bella says, what do you mean those kids? I was one of those kids. Well, you were one of those kids. I wasn't one of those kids. So you were those people. I was touched, but not in the Boy Scout way. No, I was touched in the altar server kind of way. Stacy said, I went to Akron, Ohio, the home of Cyrax, as part of an Olympics in the Mind competition. Well, there you go. Cool. You found my favorite YouTube channel, Heist. What the hell is this? All right, let me see here. HYCE. What is this? I hope this isn't something really bad or degenerate. Oh. Okay. Funny. Yes, it is a train. There's Derail Valley. What the hell is that? I've never heard of that. But speaking of that, chat, tomorrow we're going to do some, the afternoon, we'll do some train sim. I'm going to fire that up. We'll do some train sim for the new year. Tomorrow night, we are going to do the new year. 2.0 is going to hang out. And we'll do some games, and we'll do game night where you guys can like come on. We might play the game from last year. We might do some like Jackbox and What the Dub. But I'll set it up so you guys can like get the link into the StreamYard. You don't have to be present on screen, but that way you're seeing it in real time and you can react. That way there's no lag. I mean, we'll try to figure something out. But we'll have like as much as you guys want to get involved. I think it'll be a fun time. But I'll have to watch this guy. I'll have to watch this guy. Oh my gosh. Let's see. Anime Exceptional says, I got a high score for the test qualifying for Mensa and Mega. Never heard of Mega. I was in the gifted program too, and I grew up in a dysfunctional family, which limited you. I can do it. That can do it. Isn't the test malleable? Like the speed of answering them is a huge factor. I mean, sometimes it could be. Yes, Somali fraud in Columbus is now being exposed. Yes, there's all kinds of shit going down. And I love the cope of, well, actually, we already knew about it. It's like, then why didn't everybody know about it? Nobody knew about it. Nobody knew about it. There's a reason why it was kept quiet. Yes, Luke is saying this is the re-segment of the program. Afton says that tracks. I testified at 142. I'm awkward as a fuck and have major executive function deficits. I mean, it can. I mean, yeah, it's tough. How do I get into the high-end prison? I don't know, Kate. Trust me, I'm not the guy who can help you. Stephen Cooper for 20 subs. Let's go. Thank you guys for the support. I appreciate it. And it gets you guys, even Clyde Coin. Clyde Coin's going to the moon, chat. Just go along with it. Look at that. He's so cute. I keep forgetting about this one, but he's so cute. He's so cute. Get your Clyde Coin, chat. Get your Clyde Coin out there. Let me see here. You guys are calling it cooties. No, they're not cooties. I've seen more horrors on this channel than any of the horror channels I watch. That's because real life is a horror show. You're never having sex again? Well, just be careful. Yeah. That looks painful? Oh, sure it is. Show a multiple sclerosis MRI. Oh, fuck that. Yes, Ron Jeremy fucked himself retarded. Yes. Yes. Let's see here. The French Foreign Legion should be a punk band. I bet it is. Yes, Super Iron Bob says gifted and talented with Sparta's special ed. Yes, because it was the other side of the thing. Before special ed was eaten up by the special kids. Yes. I have autism. Well, I'm very good socially and regarded in relation to understanding directions of physical location. But I'm really smart with most other things. Yeah, and I mean that's a very normal situation, the whole social cues thing and social interaction. Yeah. Yeah. My cat's name is Carrie, says Ron Jeremy has syphilis. Oh yeah. Yes, he does. I gotta catch up here. You guys are flying way too fast. Hasn't Trump claimed to be 167? Yeah, he's not. That's like everything Trump says. Oh, this happened? No, it didn't. Like, I don't fucking believe him. I'm sure he's not stupid. Like, can I see him being like 120 or something? Sure. Is he smarter than me? Probably. But yeah. Kind of, that's why I'm saying an IQ that high would be impossible. I mean, it's not impossible. It's just, yeah, it'd be really difficult. It'd be really, really difficult to have. Acquired fat is -1 IQ point. Well, God, I've lost a lot of IQ points then. Yeah, go to a store and try mattresses is not a bad idea. This guy, is he the guy that's got like an actual narrow gauge railroad in Illinois or Chicago? I mean, I think I've heard of this guy before then. Okay. What is this here? So, let me see here. All the choo-choos, yes. How did I not know about this channel? Gay and Trains is right up my alley. Well, you don't know about all of them. It's like knowing every model channel. So, Shredder says, what are we doing tonight? Well, I don't know. We might keep working on the Sepp Allerberger model. If you guys don't remember, we got to get this guy painted and get him going here. So, we'll work on that maybe a little bit. Meme is covering the Minnesota scammers. Yeah. Yeah. Am I enjoying Stranger Things? I've never watched a fucking episode of it. So no, I don't know shit about Stranger Things. I know there's that chick who wears the Ahoy hat with the meme where she's holding the fucking clipboard. That's all I know about Stranger Things. All I know about Stranger Things is the memes. I don't know any. And somebody on Flashcast said that's the ice cream lady. So that's all I know about it. All I know about it. So, Stephen Miller is the 167 in the administration. I could see that. I definitely could see that. John says, I sent you a Lily Tino pic. You're welcome. I don't know. No, I don't want a pic of Lily Tino. Thank you very much. I appreciate that. I sent you a perineum sunning video. Yeah, I'm good. I'm good. I don't need that. Let's see here. I lived in the D&D era. Yeah, but I never did D&D. It was never my thing. Let's see here. He sent me a funny video of a white woman and cows. I think let me go back through and look for it. I probably have. Let's see. Oh, Anime says, I learn a lot from you, and I find you very entertaining and kind-hearted. Well, I'm glad you learn a lot from me. I'm flattered by all that. You're a good man, Mr. I appreciate those comments, guys. But like I said before, it's, and I don't mean it to be mean to you, but put out your faith in princes. I'm just a guy on the internet who acts like a dipshit. Like, I appreciate those comments, but once again, put out your faith in princes. Put out your faith in princes. Bible is always good to trust when it comes to that stuff. Like, that's all I'll say. That's all I'll say. Oh, let's see. You like it, and I'll remind it and DM it. Okay. I did like it. Okay. I think I probably did. Oh, Katie says, I own you. Putting out your faith in tards on magical boxes. Yes, that too. Yes, that's true. Yes. Putting out your faith in retards on the talkie box. So, all right, guys, that is it for tonight. I think I've got everything here. Let me check. Like I said, I wanted to give you guys something a little different than normal. If you guys didn't like it, that's okay. We won't do this again. Stephen Cooper says, here's to the gifted in chat. Well, thank you, Stephen. And I think that's kind of it. I think I got everything. I think I got it all. Kill Billy says, he's within the range. He's disqualified. He's not a tard. He's tardless. Yes. Let's see. Did I get everything else? I think I did. So. You like hearing these? I think it's important. You guys liked it? Well, I'm glad you guys liked it. I was more of a Call of Duty, Doritos, Mountain Dew, and Xbox Live racism kind of guy versus Dungeons and Dragons. Yeah, but as a kid, though, I mean, Xbox didn't come out till I was 16. Xbox didn't come out till 2001. At least I didn't get it till then. So no, before that, it was like fucking Counter-Strike. Dawn of War. Believe it or not, like I said, I played flight sims as a kid. Like all the Jane's fighter sims that you could play. I was a flight sim guy as a kid. I used to play like Jane's Advanced Tactical Fighter, where you flew like the F-22 and stuff like that, or the U.S. Navy fighters. You did the Vietnam campaigns and stuff. I flew all that. I did those as a kid, a ton of those. And then yeah, like Rainbow Six. I was heavy into that. Then Counter-Strike. So yeah. Then I did become I'm not a big Mountain Dew guy. I'm not a big Mountain Dew guy. But yes, a lot of Call of Duty. And yes, Xbox Live racism or Halo racism too. Halo 1 and Halo 2 had its own unique vibe. Let me tell you. How about Rare Breed suing? Yeah, we need to get into that. Okay. I think we're all there. I had those on PC. It sucked. Oh, well. Also, Air Warrior 2. That was a really good game. Did you get an Aces High? No, like I said, I did Air Warrior 2. That was my World War II one. But all the Jane's flight sims, so like F-15 Eagle, U.S. Navy fighters, ATF, the Longbow series they did, Delta Force 2. Those were all fun. I'm like the guys in Mountain Blade server chanting 1488 while playing the Nords. I haven't played that, but I've heard Mountain Blade is hilarious. I have not played it. Let's see. Red Baron 3D was legit. Yeah, I did not play Red Baron, but I knew kids who did. Siphon Filter. Siphon Filter is not as good as Splinter Cell. Siphon Filter is pretty cool, though. Siphon Filter is pretty cool. I love the taser in Siphon Filter. So, okay. As long as you're racist, that's what matters most. Jesus. All right, guys. So from here, we're gonna wrap this up. We might do some model paintings. I actually don't have anything scheduled for tomorrow. I just gotta take care of some phone calls and stuff like that. But yeah, we'll do some painting here in a minute, and yeah, we'll probably kind of leave it like that for a minute, and yeah. So in the meantime, chat. Actually, hold on here. Yeah, give me a couple minutes. Well, I still have work tomorrow. I just don't have to go anywhere, so it's kind of nice, but I still have to do work. So that's what we're doing here. So schedule for later. We'll just do. Hold on here. All right, chat. I will see you guys in a couple minutes. And until then, chat, just remember till next time, just because you did it does not mean you're guilty. Although whether or not you're retarded is a separate matter. So good night, chat, and take care.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy Rick Hayden yelled at? Why, yes it was, he even knows he's fat. For all this fun and more, there's one place to go, here on Sean Martin's Potentially Criminal Show. smithing and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws.